Hello everybody. I'm delighted to open our workshop, Cross-Border Families Under COVID-19. For the past year and a half, we are witnessing a horrible pandemic that has changed our lives, our world. In some countries, such as Israel, it seems that the virus is contained and that life are coming back to normal. In other countries, such as India, the struggle goes on. But if we learned anything from this crisis, is that we are all connected, whether we like it or not. 3 days ago, new cases with the Indian variant were discovered in Israel. So it is not over until it is over globally. Soon after the pandemic erupted, it became clear that it has dramatic consequences for cross-border families. Also known as world families, transnational families, and global-bordered families, these families are located in more than one country, be it due to voluntary or forced migration that separates couples, parents from children, or other family members, or due to globalization that allows people to form familial relations although they are living in different countries. Millions of families are negotiating borders in the shadow of social and legal scripts that are lagging behind, still imagining the family as a unit in which all members are present in the same country. The pandemic, with its borders locked down and other intense emergency regulative changes, provides alarming evidence of the social legal vulnerabilities of cross-border families. It reveals deeply shared norms and contested perspectives on familial rights and national interests. We are here today to hear about transnational couples, cross-border reproduction movement, child abduction, and the material sphere of world families under COVID-19. So to start the important and fascinating conversation regarding the challenges and opportunities created during the crisis and lessons to be learned for the future. I wish to thank the Minerva Center for Human Rights at the Tel Aviv University Law Faculty, and especially Professor Liora Bilski, the head of the center, and Rachel Kleinsberg, the secretary of the center. I invite Professor Bilski to greet us.
Thank you, Professor Hacker, and hello, everyone. I'm really excited and thrilled to be here with you in this important and topical conference. My name is Liora Bilski, and I am the director of the Minerva Center for Human Rights in Tel Aviv University. And I won't be long, just to give you the context. Here in Minerva, we got a grant for globalization and internationalization of the center, and Professor Hacker was the immediate candidate for such an endeavor. And indeed, when she suggested this conference, that was accompanied with also a lot of research towards it, I was thrilled because I think that this is one of the bigger challenges that the pandemic present us with. We have the Zoom that connects us, but families themselves are really apart. So I'm really looking forward to the conference and to the keynote speaker of today, Professor Yuko Nishitani. Welcome to our Zoom conference. So I wish you all good luck and looking forward to the deliberations.
Thank you, Liora. Before we turn to our guest speaker, allow me to thank also our scientific committee members that help conceptualizing and organizing this workshop. Professor Paul Beaumont from the Law Faculty of the University of Stirling, Professor Katharina Bolle-Volky from Bucerius Law School, Hamburg, Professor Maxine Eichner from the School of Law of the University of North Carolina, Chapel Hill, Professor Sylvie Fogel-Bijawi from the College of Management Academic Studies, Dr. Imen Jalal Arndt from the Max Planck Institute for Social Anthropology, Dr. Sharon Shkarji from the Faculty of Law. Einat, please mute. It's not muted. Michelle, thank you. Dr. Sharon Shkarji from the Faculty of Law at Hebrew University, and Professor Tzvi Trigger from the Law School of the College of Management Academic Studies. Thank you all for your effort, wisdom, and commitment. And a special thanks to Ms. Einat Meital, the coordinator of this workshop, who assisted us through all the stages with her professional skills, devotion, and patience. And finally, thank you all for coming. We are delighted and appreciative that you are here, making this a truly global meeting. We have more than 150 people from over 20 countries, different countries registered, academics from different disciplines, as well as governmental officials, social activists, and global family members, proving how relevant cross-border families are to all societies and jurisdictions. We are waiting to hear your thoughts and comments via the chat or oral discussion. Please raise your hand or write your comment on the chat, and the chair will see it at the end of each presentation. It is my pleasure now to invite Professor Katarina Bonivolki to introduce our keynote speaker.
Thank you, Daphna. Thank you for this introduction. And it gives me, or it has given me great pleasure to be part of the organizing committee of this workshop, which has been initiated by you, Daphna. And I'm also very pleased to introduce the keynote speaker. It is Yuko Nishitani from Japan. She's a very well-known scholar in private international law and business law at Kyoto University. She not only speaks 7 different languages, also her CV reads like a travel guide to all important law schools in the world. She completed her studies at Kyoto University. Then she did research in Hamburg and in Heidelberg. In Heidelberg, she received her PhD. And later on, she was awarded the first Lucia and Rolf Serig Prize. She did further research in Milan, in Florence, in New York, in Paris, in Hamburg, in Cologne. And she has been a visiting professor at Duke University, at New York University, in Belgium at the Catholic University, universities in Zurich and Lausanne, Brescia and Urbino in Italy, Tel Aviv, of course, University, and in Taiwan at the Judges Academy and National University of Taiwan. So you see, she is really a globetrotter. Dear Yuko, when we see each other at the curatorium of the Hague Academy of International Law, we usually do not have the time to discuss our research and publications, but at several occasions, I had the chance to listen to your lectures, and I'm sure that also today you will enlighten your listeners with a comprehensive, well-structured, and exciting presentation. And this will last about 30 minutes. And then we have some time for questions until 2 o'clock. Yuko, the floor is all yours.
Thank you very much, Katarina, for this kind introduction. And thank you, Daphna, so much for your kind invitation and arranging everything. And I'd like to also sincerely thank Minerva Center for Human Rights at Tel Aviv University for holding this conference. And I'm very grateful to all the friends and colleagues who made it possible today. Thank you so much. So today I have the honor to give a keynote on new frontiers for cross-border families in the era of pandemic. Wow. So this statistics shows what kind of flow of foreigners and Japanese we have had since January 2020. And before we had several millions of inbound and outbound movement of people. And it was suddenly dropped, of course, for several thousand in April and May last year due to COVID-19. And then all over the world, states introduced lockdown and travel ban, and state adopted emergency measures and restricted in and export. This caused various problems, cutting off supply chains worldwide, separating cross-border families, and leaving vulnerable people without protection. So we also see discrimination against Asians due to anxiety and stress in the society. All these phenomena indicate inherent risk of corona nationalism. So this poses also challenges for cross-border families and global society. First, I'd like to show the relationship between state and society. Before COVID-19, we had a globalized society, and we enjoyed people moving around across borders. Free movement was guaranteed, and migrants and foreigners were flowing into Western countries. They constituted their own communities, sharing their state of origin, religion, or ethnicity. So the societies became multi-ethnic and multicultural. In regulating family relationships, the secularized state family law in the West respects autonomy of individuals. It protects non-married couples and same-sex couples as well. And consensual divorce has been introduced in some countries. These minority groups created within the society can realize their values within this framework of state law. In religion-based legal systems in other parts of the world, religious communities play a role and interact with the state. When it comes to private international questions to regulate cross-border family relationships, the main connecting factor has switched from nationality to habitual residence. Freedom of choice of law is extended also in family relationships. So the regulation of family relationships is largely left to the party's choice. This is why the society itself has been positioned higher than the state, so to say, in regulating family relationships. But this has changed in the COVID-19 crisis. We have experienced lockdown and travel ban, and states undertake strict border control. Immigration and visa issuance are restricted, and we unfortunately see clear distinctions between citizens and non-citizens with regard to their rights and obligations. And family reunification has been restricted as well. So suddenly in the COVID-19 crisis, we see the reversed relationship between state and society because state started to regulate the movement of people and the relationships between citizens. This poses new challenges in the COVID-19 crisis. To combat our crisis, of course, states had to implement strict emergency regulations for the sake of public health and risk management. However, states cannot go too far, in my eyes. In order to rebuild our global society, states ought to be seen as a guardian of families and individuals, grounded on fiducial duty, in my eyes. Citizenship and immigration policies, which have largely been left to the discretion of the state, ought to be subject to limitations nowadays. And human rights constitute an important factor to constrain the discretion of the state, in my eyes. So as to the acquisition of citizenship, Ms. Jacobi-Ganor will address later that the birth tourism to the US, that pregnant women go to the US so that the babies can receive the nationality, this has been restricted under the Trump administration. And she will address whether this kind of policy can be justified in light of people who may have justified grounds to go there for the child to obtain nationality. And perhaps we should also be reminded that the UN Convention on the Rights of the Child explicitly stipulates in Article 7 that the child has a right to acquire a nationality. For immigration policy, the Japanese authority recently refused re-entry of 2 Japanese nationals, which surprised us, of course, because the nationals should have always a free right to come back to their own country, but the Japanese authority refused it on the ground that 2 Japanese nationals did not submit PCR testing certificate. So ultimately, although 2 Japanese nationals have already arrived in the airport in Japan, the authority refused re-entry of these people. That's why these Japanese nationals were forced to return to the US and to the Netherlands, respectively. And this, of course, is a problem from the viewpoint of Constitution, because we guarantee free movement of Japanese nationals. And besides, we are a member state of the Covenant on Civil and Political Rights, and Article 12, paragraph 4 of CCPR said, no one shall be arbitrarily deprived of the right to enter his own country. So in light of controlling people's entry, the Japanese authority obviously went too far, and this kind of exercise of discretion ought to be excluded in the future in light of human rights. For family reunification, lapse is not tourism movement was remarkable, as Professor De Hart and Professor Collet will address later. Within Europe, family reunification is guaranteed by the 2004 EU directive. In addition to that, Article 8 of the European Convention on Human Rights guarantees the right to respect for family life. So this human rights norm will set a framework of the discretion of the state. And this provision requires proportionality principle and also pressing need, social need for the state to intervene. So again, Article 8 of the European Convention on Human Rights will probably serve to guarantee the family reunification also in Europe. By respecting human rights norms, state can be held responsible to act in an appropriate way, and their discretion will be constrained. In order to rebuild global society, restoring cooperation among states will also be an important task. As Professor Schutz will address, the 1980 Hague Child Abduction Convention offers an interesting test case. The convention mechanism, as is well known, guarantees that once a child is wrongfully removed or retained in another member state, then the child ought to be returned immediately to the state of habitual residence under the convention. And in order to guarantee the best interest of the child, the convention allowed certain grounds for refusal, so exceptional circumstances that allow retaining the child in the state of refuge where the child has been taken to. And the most important ground for refusal is Article 13(1)b, which says that the child is not returned to the state of origin if there is a grave risk for the child, that certain harm can be caused to the child. And in the COVID-19 situation, the question is returning the child to the state where COVID-19 is spread constitutes a grave risk. And this requires a restrictive interpretation because it is an exceptional ground for refusal. And insofar as some effective protective measures are taken in the state of origin, then the child can be returned even under COVID-19 situation, depending on the case. In rebuilding a cooperation between states, then Hague Child Abduction Convention already has established a very good administrative and judicial cooperation mechanisms. And I'm also wondering whether this kind of cooperation mechanism can be used not only before the child is returned, but also after the child has been returned. So I have been in discussion with the Japanese Central Authority, and they often did not have track what happened after a return order has been rendered and the child was supposed to be returned to the state of origin. So in order to guarantee that a safe return is ensured for the child, perhaps we could also think of guaranteeing some kind of cooperation between states after the child returns to the state of origin. With regard to cross-border surrogacy, we have seen a variety of state practices all over the world. There are still a number of countries that strictly prohibit surrogacy, whereas there are certain countries that allow surrogacy as a matter of domestic cases within their state under strict control. And there are another category of states that are largely open to also international surrogacy. So they accept intending parents to come to their country overseas and enter into surrogacy arrangement. And the surrogate mother gives birth to the child in these states. The problem is, of course, in cross-border cases, we have observed a number of surrogacy tourism that the intending parents who cannot have surrogacy in their own country go to a foreign country where it is possible and enter into a surrogacy arrangement and have the child born by the surrogate mother. The question is how we should deal with legal parentage of the child born out of surrogacy, because in light of the best interests of the child himself or herself cannot decide in which circumstances the child is born. So once the child is born, we should think of how to protect the child in the best way. And with several seminal cases and decisions of the European Court of Human Rights and several other countries, and a lot of states have been moving to allow at least some kind of recognition and of legal parentage of intending parents established in the state of birth. Or other states allow adoption to be conducted after intending parents take the child back and to their home country. The question is how we can ensure the recognition of legal parentage. We have observed in the COVID-19 crisis, as Ms. Yakovic and all will address, that babies were left at the border of Ukraine where a lot of surrogacy takes place, but the babies could not take them out of the country because intending parents could not visit Ukraine to take their children. In this kind of situation, again, I think it is important to think about the cooperation between states to allow protecting the child and guaranteeing the recognition of legal parentage. In this respect, the Hague Conference on Private International Law is now contemplating an important project on legal parentage and surrogacy. So I'm fortunately one of the members of the expert group representing the Japanese government, and we are thinking about how we can create a framework according to which legal parentage established in the state of origin in favor of the intending parents can be recognized in other states. And this will allow protecting the child and surrogate, because the convention itself, it will probably be a protocol under the current state of discussion. The protocol on surrogacy will also have necessary safeguards so that it will ensure that surrogacy does not take place by abusing surrogate mother, and certain necessary control take place with regard to intending parents and the child and intermediaries. So again, in combating the COVID-19 crisis and protecting children better in surrogacy cases, I think it will be desirable that this kind of cooperation among states can be established by the Hague Conferences project. So far, the position of the states largely differs, so we do not yet know whether this project can be launched as an official project. But I think in thinking about establishing cooperation and solidarity between states, I think this is a very good, viable way, which deserves further consideration. COVID-19 forces us to redefine our family life as well. As Ms. Marilla will address later, mixed couples have had a different form of family life in the COVID-19 crisis because they could no longer have free movement to their home country. And by living in the confined environment, they started to create, so to say, new identities. So this will change and challenge our lifestyle in the long run. And then we will probably also have to think about how we should protect women and children, particularly in confined family environment. The number of domestic violence and child abuse has increased. So this again challenges and requires further policy developments. If we think about what kind of long-term effects COVID-19 could have on the social, psychological, and economic cross-border family lives, we should also think about that the family forms will be changed, and particularly birth rate, fertility rate has been declining rapidly due to COVID-19. So currently in Japan, we have 1.34 children born in average, which is quite a low number, and Republic of Korea is even lower. And if this continues that way, by 2100, we will have almost the half of our population reduced. And this will have an impact on the entire social system and welfare system. And also in terms of family life, we will probably have less adoption in the future. So the statistics of the 1993 Hague Intercountry Adoption Convention has shown that with a lowering number of children around the world, the number of adoption itself has decreased rapidly. And this will continue in the future. So again, in terms of family life, COVID-19 requires us to think about in a longer term how all these crises will affect our social, psychological, and economic family lives. I'd like to point out some, perhaps some positive developments we have observed due to COVID-19. So COVID-19 forced us to use digital technology, and this has had positive impact in court hearings, for example. Online hearing of the party, parent, and the child have been introduced, and online access to the child has also been implemented. Of course, online hearing must be used with caution because it does not entirely substitute direct personal communication, but at least having this possibility is very helpful. And the use of technology, because it has been widely spread, this has also enhanced the use of electronic service of documents, and evidence by video recording is also very much supported. And digitalization will soon abolish personal stamps in Japan, which is used instead of signing as a form of identification in Japan. So all the public documents will be used without having stamp on the paper, and we will be able to submit our marriage application or consensual divorce application by electronic means in the future. So that will facilitate the administration in Japan. COVID-19 will also probably enhance the use of alternative dispute resolution in family matters like mediation and arbitration in different countries. And also in cross-border child abduction cases in Japan, the mediation outside court is often used because it allows online communication with the left-behind parent in the foreign country. So courts in Japan do not yet allow this kind of online communication with the foreign country, but it is possible with online outside court mediation. That's why probably the COVID-19 will have positive impact on the use of ADR in family matters as well. And the 2019 EU Brussels II regulation allows agreements resulting from mediation outside court to have binding effects, enforceability. So that will also help in the future. Now, after rapidly indicating some issues and points we can discuss, I now would like to come to conclusion. In my eyes, to rebuild a global society, it is important to combat corona nationalism. And in order to do that, we should hold states responsible to respect human rights. So also in immigration and citizenship issues, the states should not be left entirely to their discretion, but this discretion shall be constrained in light of human rights. In order to rebuild global society, cooperation and solidarity between states will also need to be rebuilt, as Yuval Harari mentioned in a recent paper. And he's a favorite author from Israel, so I'm delighted to cite his word here. In the long run, we will probably have to redefine our identity and not confined in our own small world, but think globally and redefine our identity as a global citizen to cooperate and to be open to other countries and other culture. And that will help rebuild our global society after the COVID-19 crisis. So thank you very much for listening to my talk. Thank you so much.
Well, thank you, Yuko, for this overview of important issues that have been occurred due to the pandemic. And you also referred to some of the topics that will be addressed later by the speakers in the workshop. We already have one question in our chat. And I would like to give the floor first to Shmuel Yerushalmi, and then to Daphna. Mm-hmm. Please take the floor, ask your question.
You hear me, yeah?
Yes.
Well, we cannot hear you well. And
Okay.
I think that you wrote your question in the chat. If there's any research on the impact of COVID on families from the former Soviet Union. So that can be a question to our speaker, and maybe there are people in the audience from Russia or other related countries.
So shall I just respond? I would have loved to have research also on about republics of former Soviet Union, but unfortunately my research has not yet reached that area yet. So if you could tell me more about what's happening in your state, I'll be grateful. Sorry.
Would you like to respond, Mr. Yerushalmi? Do you hear us? No, he doesn't.
I think we can move to Ruth's question on the chat.
Yes, please. I see that Ruth has posed a question, and would you like to elaborate a little on the question?
Thank you, Yuko, for a beautiful presentation. Very broad and very interesting. So just a quick question. I think several of the questions, if not all of them, are already known, and we tackled them before in different situations regarding surrogacy, abduction, and so on, and family reunification, especially in Israel, which is always a dilemma. So the question is it a new one, new dilemmas, or is it the same one, but in a more severe situation, more common? Do you find them like a new dilemmas, or the same, but more common, as I said? Thank you.
Thank you very much for your question. I think that's also the question I was asking myself. And I think in many cases, the inherent problems we have been observing became bigger in the COVID-19 crisis. So surrogacy problem existed already before, but because of the closed borders, we suddenly had babies left in Ukraine, for example. And this made me aware that cooperation between states needs to be built. And I think COVID-19 made clear the necessity of this kind of cooperation. So in a way that made clear the inherent problems, as you say, but again, that makes us also reflect on how we can combat and which way we can go. Thank you.
Daphne, you had raised your hand.
Thank you, Katharina. Thank you, Yuko, for your presentation. I think that, you know, the zoom out glance is really important in this case, as well as the case study that we will further explore in our conference. But I wish to challenge your maybe assumption in the beginning about how the world was before the crisis and how global it was, and that we were all global citizens in a sense. And I think in my book and in others' work, we show how borders were very present in our lives before the crisis, and how there were hierarchies between citizens around the world, between those who could have easily crossed them and those who could not. So I think we were never truly global. So there isn't, it's what you are suggesting is not, is even more challenging, because it's not going back to what we were, but inventing ourselves as global citizens, and what does it truly mean? And I think that, again, we have to make a difference between our normal aspirations and our empirical observations. And I think that there is a risk that this crisis will even further heighten borders. So as a community of researchers, where do you think we should look at, or what it is that we can do in order to push to the solidarity and that you are portraying, and not cooperate with even more cruel borders in our lives, in family lives?
Yeah. Well, thank you very much for your question. I think, first of all, I do agree that borders existed before, and perhaps they were a number of privileged people who could afford crossing borders, as you say. But on the other hand, if you look at the wave of immigrants and the refugees crossing borders, I think we can also say with certainty that cross-border movement of people has been occurring. Compared with, several decades ago, it was increasing, and we had more globalized world with, of course, a series of problems immanent in that. And of course, we often talk about multicultural society, integrating and immigrants and newcomers into the society has always been a challenge. But I think by COVID-19, where this kind of movement was suddenly cut off and was no longer possible, I think this created other types of problems and also created borders probably within the society between citizens and non-citizens. I also read a report of one state, which I do not want to mention here, but one state that refuses return of its own nationals because of their origin from a certain Asian country. And after these citizens visited their family, hundreds of them were left there, were no longer allowed to go to the country where they actually obtained citizenship and have the status of a citizen there. So I think I agree with you that borders existed before, but COVID-19 obviously created acute problems and created more borders and poses a lot of challenges. How we can combat is a big question, but I think COVID-19 also made clear, as you mentioned in the beginning, that we are somehow on the same earth. We are in the global society, interconnected, because COVID-19 crosses easily border and it affects other countries easily. So by having that in mind and having also solidarity as an important value we should seek, I think we should gradually move in different directions to help each other and try to rebuild society.
Thank you. Before I give the floor to Paul Beaumont, I would like to ask a question to you, Yuko, about, well, specifically the private international law approach in family matters. We have nationality, habitual residence, we have party autonomy as connecting factors, or party autonomy if we have two family members who may agree on something. And were we actually well prepared? Should something be changed? Are there any lasting effects which will, well, change, improve, well, private international law in particular?
Mm-hmm. Oh, thank you very much. That's a good question. I think the cooperation mechanism that has been set up by several Hague Conventions, that can be used in a positive way. I think, for example, in the case of child abduction, the administrative and judicial cooperation can be also used to make sure that the child returns into the state of origin in a safe way. And that would be the implementation of the existing rules, and we can perhaps use this mechanism in a different way to combat COVID-19. Whether we need a new rule, that's something I'm still thinking about. But yeah, for example, when an outside court mediation is more used in Japan, we would be grateful to have some kind of international mechanism to ensure the legal effects of this kind of agreement. And Professor Beaumont was a leader of this project at the Hague Conference, which has not been pursued as an official project so far. But I think after the EU has established this mechanism by the EU regulation, we could think of, making some kind of international instrument and mechanism to ensure the legal effects of agreements reached in a mediation. So I think gradually private international can help giving us more instruments, so to say.
Thank you. Paul Beaumont.
Mhm.
Thank you, Katerina. Yes, and thank you for that, Yuko. Good plug for family agreements. I agree entirely that one important way forward would be to have a new instrument that makes it easier for families to reach resolutions in cross-border cases on all the issues that are at stake.
Paul, can you come closer to a microphone? We can hardly hear you.
Can hardly hear me. Is that better?
Not really.
No. Sorry. I'll shout. Is that better?
Good. That's one way of doing it.
Right. Thank you, Yuko. I agree. Family agreements is a great potential way forward. The sad thing is that we don't have consensus amongst the member states. There's at least one participant in the meeting that I saw from one member state who isn't very keen. But I hope I hope your statement might encourage a change of mind. Party autonomy is important, and facilitating parties reaching agreement and then making it easy for that to transport is important. But my question was going to be on surrogacy, actually, which is your area at The Hague. And I was pleased to see you saying that you wanted some kind of international regulation. But I wonder if it's ambitious enough in order to protect human rights. I think something along the model, and I've argued this before in publications, something along the model of the Inter-Country Adoption Convention, which really does make sure that the intending parents are suitable, that the surrogate mother would be treated appropriately and not be exploited, would be a big thing. And yet so far there seems a reluctance from member states to be committed to a proper regulatory solution like we have in the 1993 convention. Is there any hope?
Thank you very much for your question. And yes, I'm fully aware of the difficulties. There are several options we are thinking about for the protocol. And one option is to establish an international cooperation mechanism similar to the 1993 Inter-Country Adoption Convention. And so far, it's difficult for states that do not accept surrogacy in their domestic law to accept this kind of cooperation for cross-border cases, even though they are now ready to at least recognize the legal parentage established in the state of birth in favor of the intending parents. So I'm not in a position to say how the Council of the Hague Conference will decide, but I think being aware of this kind of problems in surrogacy cases has been shared broadly thanks to the preparatory work so far. And even if we cannot make an binding instrument, it may be still helpful to have non-binding principles or guidelines for the future. So I think the expert group has been doing a very great work, and this can be used as the basis for any kind of future work, which will come up, I hope. Thank you.
So the next question will be posed by Mikael Bogdan. Hello, Mikael from Sweden.
Yes, thank you very much. And thank you, Professor Nishitani, for a very interesting presentation. Now, you mentioned that Japan has refused entry to 2 Japanese nationals. You said this is contrary to Japanese law, which of course I have no idea, I cannot express any opinion about, but you also mentioned that this is something to do with the human rights. Now, I suppose that this is, the situation is not as dramatic, with people dying in millions, but I think that the human rights of one person stop when the human rights of other people begin. And the right to life. And if you would have a very dramatic epidemic, I think that it would be quite okay to stop people from moving. I can hardly see that would violate human rights. I repeat, I don't express an opinion on Japanese law. What it says. What do you think?
Thank you very much. I think perhaps we can assess the risk of COVID-19 better now that we have understood the symptoms and having vaccination possibilities and so on. And in the case of Japanese nationals who were expelled and forced to go back to the US or the Netherlands, in that case, the Japanese authority did have the possibility to separate these two Japanese in a hotel room and let them stay there for 2 weeks as a self-quarantine period. And then these people could have go home without problems. So the authority can be more creative and flexible, and can and should also take more less intrusive measures to respect freedom and other human rights of the people. So I still think there is, wider leeway what the authority could do, and that's probably our task to, indicate and point out what they should do in that kind of situation.
Thank you very much.
Thank you.
We have now a question from Bulgaria in the chat, but this topic, international abduction under the Hague Convention, will be addressed by Rona Schutz as well, and probably we can answer it there if there are no other questions at this moment. And Michael, you still have your hand up. Do you have a second question? You are muted. I can't hear you. Okay, now it's down. Yes. Any other questions to Yuko? Now is the moment to ask everything you always wanted to know. Well, if this is not the case, then I would say we finish here. We have some time extra for the next presentations. And I would like to take the opportunity to heartily thank Yuko for her keynote, which was a very nice introduction into all the problems that we will discuss this afternoon. Thank you very much, Yuko. And as I said, the question about international child abduction will then later be addressed when Rona Schutz has given her presentation. And now I give the floor to Imen, who will introduce the other speakers. Please take the floor, Imen.
Thank you very much, Mrs. Bolivolki. Thank you very much, everyone, and good afternoon, everyone. My name is Imen Galala-Arndt. I am an Associate Research Fellow at the Max Planck Institute for Social Anthropology and Department Law and Anthropology in Halle, Germany. And it's really my pleasure today to chair the first session in this pioneer workshop on the repercussions of COVID-19 on transnational family. We will start from the beginning when two persons love each other, whether two men, two women, or heterosexual couple. And as we said, that there is nothing new under the sun, but this crisis urged us to think, to go inside and to rethink about what was already there, and to think more deeply about the meaning of love and the repercussion of love on the repercussion of this pandemics on love, maybe as a legal category. But we will think about it and discuss about it in the coming hours. For this session, we will have two excellent presentations by Professor by Professor Betty de Hart and Professor Beate Colette. And then Professor Daphne Hacker will make a comment on these two presentations. At the end of the session, we'll collect the questions, whether by chat or by raising your hand. Professor Betty de Hart will have the first presentation, as I said, and let me please make a brief presentation of her. She's professor of transnational families and migration law at Vrije University of Amsterdam. Her research approach is very pluridisciplinary, legal, empirical, and historical. She works on, as I told you, on transnational families, and she's the recipient of the very prestigious European Research Council Consolidator Grant. Her project is on Euromix, regulating mixed intimacies in Europe. And in 2007, she also received a very prestigious national grant from the Netherlands Organization for Scientific Research on transnational families between Dutch and Islamic family law. And she has also an excellent list of publications. And if you, during a weekend, want to relax a little bit on YouTube, I suggest to listen to her excellent inaugural lecture of 2019 on race, mixture, and law. So, Betty, without any delay, we are all ears, please. The floor is yours.
Of course, yeah. Thank you for this kind introduction, and thank you for having me. I was very excited to see this call for papers for this conference because, of course, the whole COVID situation makes you think again about transnational families and how it affects them. So I try to follow that a bit, and this paper, and which is very much work in progress, came out of this. I must warn you beforehand that I'm a migration law scholar, so not so much international private law. So this will become clear also from my presentation. So my presentation is on the Love is Not Tourism campaign that I'm assuming that at least some of you have noticed. It was an online social media campaign from cross-border couples, binational couples across the globe, complaining that they could not be together because of the closed borders. And as before academia, before I started to work in academia, I was connected to and still are to some extent connected to NGOs of mixed couples. I was very excited to see this campaign on social media and also in the mainstream media picking it up. So I started to look at it, and then I started to be concerned a bit also about it. So this paper comes also from out of this concern, which is not so much legal, but more, you could say social legal, or also bit normative, you could say. So I think one of the interesting aspects of this campaign is that it is, as I see it, at least in the Netherlands, but I think also more globally, about migrants who are in a rather privileged position, or couples who are in a rather privileged position. They are migrants of privilege, and although lots of the transnational families literature focuses on families that are not so privileged. They are privileged in several ways because they have enough financial and social capital to travel around the globe easily. And are on the good side of global mobility. And what I want to understand is how we can understand this campaign of Love is Not Tourism against this background. So for the methodology, I looked at law and policy documents, case law, and media reports and social media outlets. And what I want to do is not so much a legal analysis, but a discourse analysis. So what are the discourses that this campaign produces, and how is it picked up by the media and policymakers, etc. So my unease about this campaign started with this media outlet in a major Dutch media outlet. The heading reads, "Love conquers all, but closed borders make it quite difficult." As somebody who has been working on family unification policies for a long time, it made me think about several issues that I want to present to you today. So you had more of these media outlets in Dutch media presenting, this romantic love couple on a beach, sun is shining, they are kissing and hugging. This is a couple of a Dutch woman and her American boyfriend. And they are not married yet. They met like a year ago, or 1.5 years ago, and they visited each other in the Netherlands and the United States, and now they could not do that anymore. So the two questions that I had when looking further into this campaign was, well, these are actually not difficulties due to COVID. And also that for many transnational couples and families, the borders are closed even outside of COVID. And there is no easy traveling around the globe for many families and couples. So this was where my concern about this campaign started. And I will explain it a bit more to you. But before that, it was, in a sense, quite successful campaign. I think that a lot of media attention was paid to it, and also very quickly, I think, if you compare to some other campaigns that have been around on migration or family migration, I think the European Commission picked up on the campaign, expressed support of the campaign, and urged member states to allow for traveling of family members of EU citizens, that they had the right to residence and not to keep them out, even if the couples were unmarried and did not have a long-term relationship yet, because they were in the stage of developing this relationship. And the Netherlands also quite quickly after that, 1 month later, responded, and several other member states did so too. I must say that the results in the end were quite mixed, because then after a while, some member states, including the Netherlands, also reinstated these travel bans again. And so in the end, I think the results were also quite mixed and not as successful as they initially seemed to be. So as I said, well, this is not the most serious problem or the main problem due to COVID. I've listed here the migration law consequences of the COVID situation. So the measures that the Dutch government took in response to COVID. So visa applications were for a long time not possible. And if they were made, they were often refused for issues also of COVID. So it was said, well, maybe you have a right to travel, you have a visa, but you cannot come because of COVID. So long-term visa that allowed them for family unification were not taken in for a long time, and also often refused. While on the other hand, people who were already in the country, they were said to have to return to the country of origin to apply for this long-term visa. And if they could not, due to their travel restrictions, they ended up in a situation of illegal residence. No DNA tests were taken, which is often, or not often, but sometimes required for proof of parenthood of children. No pre-entry integration exams were taken, which are required to make family unification possible. No naturalization request, no legalization of documents, no exams for the integration text that is required after arrival in the Netherlands. And more for the longer term, there's uncertainty on what the consequences are if people use the economic support that the Dutch government offered, what the consequences may be for residence rights, because people have to meet income requirements. So this is just one of the, some of the consequences, of course, outside of family. I stuck to family unification, and outside of that, there are also, of course, for asylum seekers, for people in detention, very severe consequences also, but I leave that out of this paper. These are just on family unification. Then outside of times of COVID, the Netherlands is not really known for their liberal family policies. Yuko mentioned that before COVID we had free movement. Well, no, we did not, or maybe only some people. And that is one of my concerns also about this campaign. So Netherlands is among the strictest in family reunification policies globally, together with some other EU countries like the UK and Denmark, as the NIPEX index shows. This is due to, for instance, the income requirement of 100% of the minimum wage, the long-term visa that are required with this, which have to be applied from abroad and not inside the country, the pre-entry test of language ability and knowledge of Dutch society, quite strict controls of marriages of convenience, and integration test after arrival in the Netherlands. And permanent residence or independent residence for which a successful integration exam is required is possible only after 5 years of residence. Also independent residence, with that I mean that it is no longer dependent on the marriage or family relationship, which keeps especially women in situations of dependency and maybe even domestic violence. So these are requirements that are permitted by EU law, the Family Reunification Directive, and also by the European Convention on Human Rights. Article 8, as what was mentioned by Yuko, actually does not give a right to family reunification, only in exceptional circumstances. These kinds of requirements have largely not been addressed by the European Court of Human Rights or have been accepted. And the same counts for the other European Court, the European Court of Justice. So these are the normal COVID times, not non-COVID times. So this is so there is no free global traveling. These are the crimes that people have to deal with, and of course it affects some transnational families, in another way, in a different way than others. So these requirements have gendered and racialized effects. Gendered, because as we all know, income requirements always disadvantage women because of their disadvantaged labor market position still there, and also because of care tasks. Income requirement that the Netherlands has affected men and women differently. But also if you connect gender to also ethnic or racialized background, I will use these terms cautiously, so between brackets, then you see that for Dutch white males, the drop after the introduction of a strict income requirement was 22% of applications, and for Turkish female sponsors, it was 57% in drop of applications. So you can see that it really affects people differently, and then transnational families very differently. And the same counts for the pre-entry test. So you have countries where the family migrants from certain countries have no problem in meeting this test, which has to be done at the Dutch embassy on the computer. So it requires computer skills. So this is a disadvantage of digitalization, I would say. For some other countries, the pass rates are very low, actually. So what I'm suggesting in my paper is that what the Love is Not Tourism campaign is claiming is actually the free global movement that they had before COVID, that other transnational families did not have, but they had. For instance, this couple that you saw before had a Dutch with a white American. They could freely move between the Netherlands and the US, but many other transnational families cannot move that freely between two countries. And this is not arbitrary, but here you see on this map the countries that have the nationalities that have more than 100 visa applications, and those who have less than 100 visa applications. which sort of coincides with countries that we consider sort of white and countries that are considered sort of black or racialized. I understand this not as a biological category, but as a social category that is produced by social actors. So this is what they actually claim, this Love is Not Tourism campaign, at least in the Netherlands. Maybe it is different. I'm curious to hear from Beate how it worked in France. But at least in the Netherlands, the couples that were involved in this campaign did not mention any other issues of family unification policies, for instance. So certain issues were in the media and they were welcomed in the media, met with sympathetic response in the media because they represent a certain kind of transnational families or couples. And for others, it's much more difficult to enter the media and to gain such a sympathetic response. On the contrary, family unification policies have become much more restrictive over the years because of the intention by the Dutch government, and not only the Dutch government, but also other European governments, to keep certain transnational families out. And what the different map that was produced by the COVID situation is this. It's not white and black anymore, but yellow, orange, and red. And this is what these Love is Tourism, Not Tourism couples are facing. And this is what they are protesting about. They want to return to the former map, actually. Yeah, so as a person feeling connected to this kind of NGOs, I have some normative concerns also with it. And I also think this is a concern that I have also for a longer time also with other sort of campaigns. And my concern is not only that it is, normatively there are some issues with it, but also that it is maybe not effective and that it would be better to build coalitions with other transnational families affected by it, which would result in a much stronger campaign where you could challenge family unification policies, for instance, much more fundamentally. So these are my preliminary concluding remarks. And as I said, it is very much work in progress. So I'm very eager to hear your comments and help me to think further about this. So what the Love is Tourism couples claim and the media presentation, it's not only them doing it, but also very much the media involved in it, is the white privilege of global mobility. And what also struck me in the media outlets is that although initially I intended to focus on citizenship and belonging, that they don't really claim citizenship and belonging that much. They claim global mobility. They want to continue this easy global traveling, what their life used to be. That is what they want, actually, much more than the citizenship and belonging. So I think the silencing of the experiences of other transnational families that are on the wrong side of global mobility, also outside of times of COVID, is problematic. And that this campaign of Love is Not Tourism is not the only campaign doing that. For instance, if I have time left, I'm not sure how I'm doing on time, so shut me up if I take too long. But for instance, there's an organization of Dutch immigrants, and it's not the first one. It has been going on for decades. So they want dual citizenship for Dutch immigrants. And they present themselves as we are entrepreneurs, we are very good for the economics of the Netherlands, and this is why we should be allowed to have dual citizenship. And I questioned them. So last week or so, we had an email conversation, and I asked them, so only for immigrants? What about Dutch? What about immigrants in the Netherlands? They also want it, maybe. So do you have any contacts with them? I said, well, no, we are also involved. At first they said, well, formally we don't have a mandate to do that. And then it turned out that they are also involved with political parties who actually are against migrants in the Netherlands. So yeah, they actually only claim it for Dutch immigrants and don't want to claim it also for Dutch migrants in the Netherlands, and build coalitions because they feel uneasy about migrants in the Netherlands, certain migrants, of course, in the Netherlands. In Denmark, you have even more stricter family unification policies than in the Netherlands. A campaign by Danish expats, because then they are not called migrants but expats, has resulted in a 28 years rule that from these restrictive policies, those Danish citizens who had been citizens for 28 years were exempted from this rule. This was the result of this campaign. But after the European Court of Human Rights thought this was a violation of equality principle, Article 14, the previous very strict family unification policies were reintroduced, affecting the Danish expats again. So here you can see also how this campaign, in my view, is not effective. Also, these kinds of campaigns is not effective. And then I have a lot of question marks. So I hope you can help me with the question marks. This was my talk. Thank you very much.
Okay, thank you very much. Again, thank you very much, Betty, for this presentation, for these lucid remarks, and as at the beginning said, this pioneer work. So I'm sure that there will be, that your presentation will raise in the audience afterwards many questions. And then I would like to give the floor to Beate Colette, Professor Beate Colette, who will also go over these topic of international, transnational couples from maybe another, focusing on another part of the world, on France, and with another method. And let me please present Professor Beate Colette, who is an associate professor in sociology since 1998, first at the University of Lyon, and since 2007 at the Sorbonne University in Paris. She is a member of the research unit GEMAS, and her research and teaching bear on migration, inter-ethnic relations, mobility, gender, and family. She promoted in her habilitation work a theoretical conception of conjugal mixedness. So I'm really very curious about that. I would like to find a relevant article on your theory, and maybe you can, during your work also for us today, give us some premises of a theoretical conception of love in times of pandemic. Who knows? Professor Colette also has an impressive list of publications. I just give you as an example the review of Polish diaspora in 2017, where she published an article on conjugal mixedness in France, marital norms, and inequalities in inter-ethnic relationships. She also organized many impressive conferences, and her last publication was on the choice of the name in international couples. So, Beate, the floor is yours, please.
Thank you very much for giving me the opportunity to present my work in this international global workshop, and thank you very much also for your nice presentation. I will share, I think I can share my thing, my screen, so I will. Normally you should see it, yeah?
Yes, we do.
Okay, fine. So my topic today is transnational love under COVID-19. how the travel restriction reveal international conjugal arrangements. So as a matter of fact, compared to Betty, my point is more from a sociological point of view. The travel restriction decided due to the COVID-19 crisis shed worldwide light on the consequences for international mixed couples and revealed the high internationalization of marriage and conjugal life. The more and more persons in all countries have intimate relations with partners abroad. Easier and cheaper mobility facilities, even over long distances, contribute to high international mobility for multiple reasons. Travel, even over long distances, travel, single people working and studying for a certain period outside of their home country, increase the opportunities to meet a partner abroad. Whereas in the last decades of the 20th century, mixed couples in European countries occur mainly as a consequence of immigration to these countries, since the beginning of the 21st century, mixed couples are more and more an indicator for a global internationalization process. These cross-border couples or transnational mixed couples are a specific feature in a wider sociological fact called conjugal mixedness in my own work, of course, but we can recognize more and more, although this kind of terminology in other publications. What is meant by that thing, conjugal mixedness? It includes in a theoretical way it's a theoretical frame for all different features of mixed couples. And cross-border couples are only one of these features, because a lot of mixed couples are formed of two persons living in the same country. One is native and the other is immigrant, or both are immigrants but from different countries, or again, both are natives but with different racial belonging or cultural or religious background. Though all these couples may be called mixed couples. So cross-border couples are only one specific feature of it. For me, conjugal mixedness means being a mixed couple is not only a question of culture or religion, but also a question of gender and class power relations, and even of a different legal status of the partners. Saying this, I decided to keep a strong link between mixedness and intersectionality of gender, class, and race. The general travel ban decided by national governments to limit the outspread of the COVID-19 virus had unintended consequences for couples in which partners live in different countries, so-called cross-border couples. They were simply forgotten by national-driven measures, which especially in the first lockdown period did not anticipate international regulations on the pandemic. All people who travel between different countries were of course affected. Their normal mobility was totally reduced. However, for couples and families, the emotional load is higher and they do not feel as normal travelers. Especially the ones who need visas to join each other were prevented to meet on a regular basis, and many of them were not able to have common moments over months. But even couples, the so-called living apart together, used to meet on weekends, and where each partner lives on one or on the other side of a common country border, could not join anymore if their country decided to have observation of a quarantine for people crossing the border. So although these couples living not so far away from each other are concerned by the restrictions. Concretely, these analyses are based on newspaper articles. So I have to go on. Methods, yeah. Concretely, my analyses are based on newspaper articles in France and in Germany, and on statements and activism of these couples through different media. Since July 2020 emerged a specific international internet activism called Love is Not Tourism, which fights for reunification of transnational mixed couples separated by the COVID-19 governmental measures. The aim is to put pressure on the governments by signing petitions, doing lobbying work, and informing the public opinion to obtain special rules for international mixed couples. In France, and actually in Love is Not Tourism, is also a possibility for concerned couples to exchange about their experiences. In France and Germany, local groups of network are active on internet and social media, Facebook and Twitter, and nationally organized self-defense groups, or ONGs, as Betty said, picked up the issues. In France, we have the group called Les Amoureux au Banc Public, and in Germany, we have the Verband Binationaler Familien und Partnerschaften, who picked up this Federation of Binational Families and Couples. And let's say the French organization, we can translate it by People in Love Facing Public Restrictions. The varied material of life experience of mixed couples and testimony of their activism to obtain recognition of their specific situation gives a profound insight in the changing situation of international mixed couples. COVID-19 crisis is another example how governments intervene in private life sphere when non-citizens are concerned. While love is going globalized, the national political frames tend to restrict these contemporary changes. The presentation will look on transnational mixed couples condition during the COVID-19 lockdown from spring 2020 until today by adopting a sociological approach. Due to my conceptual approach, I do not call them binational couples to avoid the illusion that the two nationalities may be equal. Even if the partner in their daily life are able to come over their difference of nationality or culture, their legal situation or their general image is different from country to country. Furthermore, when transnational features come into play, one partner is from outside, whereas one from inside disposes rights and social privileges as a national citizen. A first section of my work my presentation deals with the way different European countries consider the situation of these couples from an administrative standpoint, giving or not recognition to these couples, and defining in a way the normative thinking of what a couple should be. The second section analyzes how the concerned couples, who are the concerned couples, and how they get organized to defend their purpose. All in all, the COVID-19 crisis reveals the increasing internationalization of love. So how do European countries facilitate or not transnational mixed couples to reunite under COVID-19? So we will go to, it's a lockdown, so COVID-19, the pandemic, with its lockdown regulations on national driven decision, puts a general curb on transnational mobility to limit the international outspread of the virus. But by doing so, these decisions reveal the complexity of modern social life, which is more and more related to virtual and spatial mobility. As a matter of fact, European Union member states did not decide in the same way, despite the European recommendation. These measures affected directly transnational mixed couples. Today, many countries propose travel arrangements for unmarried mixed couples, but without the activism of Love is No Tourism, this would not have been possible. The website of the global grassroots movement is a good example how social media activism may work. The website gives information. petitions, letters, Facebook groups, contact to members of the parliament for more than 50 countries. The main argumentation is, we understand the travel restrictions, but we are not tourists. We are couples in love living with several reasons for several reasons in 2 different countries. We want to be reclassified as essential travel. This means willingness to submit to appropriate safety regulations. So they will do self-paid tests upon arrival or quarantine, but the possibility for unmarried couples and families to visit their most important loved ones should be given. So in Germany, the separated couples won the case in a way. From the 10th August 2020, unmarried partners from 3rd countries who are not on a special list, this is the exception, are allowed to visit their partners living in Germany. German, UA citizens or 3rd country nationals with an existing resident permit in Germany. They need an invitation, the foreign partners need an invitation from the person which is a resident in Germany, and a so-called relationship declaration form signed by both partners, and they have to show up proofs of previous personal meetings, passport stamps, travel documents, photographs, letters, or emails, social media correspondence, etc. Several updates from August 2020 until now completed the rules. The Organization of Binational Couples and Families, which is a long-established organization to fight for mixed couples' rights in Germany, also did a lot of lobbying and published on its website a kind of diary written by separated mixed couples in Corona times to sensibilize on these specific issue. In France, the situation seems a bit more complicated. Apparently, the government adopted at the same moment similar rules. Couples where France is the main country of residence for one person can apply for a pass, for a laissez-passer, for the other partner to enter. Couples must present documents at their local consulate to show evidence of one partner's proof of residence, identity documents, return transport tickets, and so on. But they must also show proof of the relationship, the proof that the relationship is lasting and sentimental, showing common invoices, bank accounts, rental lease agreements, and passport stamps of frequent visits to the country. The second condition depends more obviously on the appreciation of the authorities. The French group of Love is Not Tourism realized a survey end of August 2020 to have first impressions how the procedure worked. 218 couples brought in interesting answers. Only about 10%, 10% of the consulates did not answer or were not informed about the procedure. 75% of the couples were not informed how long the procedure will last. They asked for facilities, but they were not even informed how long it will take. More than 45% of the couples were asked to hand in a precise travel plan through which countries they will go. 20% had to buy the ticket before getting the visa delivered, the air ticket before the visa was delivered. At the moment of the survey, at least 85% did not get an answer to their request. In April 2021, this French group did again a new survey, and this time 448 persons contributed. Still, a lot of couples do not know about the laissez-passer, and half of the requests were refused. 1/3 of the couples did not come together since the beginning of the pandemic, while the others in France, okay, sorry, I cannot read what is written here. Okay, 1/3 of the couples did not come together since the beginning of the pandemic, while the others did see in France or in another country even without obtaining the laissez-passer. Because, you know, rules in France, you have them, but they are difficult to occur. So people they find non-official solutions to organize themselves. Hence, we can conclude by the following observation. I think I don't have this. Okay. On the way national governments dealt with the pandemic travel ban for transnational mixed couples. By putting a lot of informal constraints on the transnational couples in France, instead of trust in their declaration being a couple, they did not get the laissez-passer. By doing so, the couples are encouraged to invent other non-official solutions, meet in third countries, or getting together without the laissez-passer. Couples posts in the two countries confirm these national differences. More generally, without the love is no tourism activism, despite the fact that these are more privileged couples, I agree to this, the specific situation of cross-border couples would not have been taken in account. Their lobbying contributed to put a public interest on their demands, but solutions are not satisfying for all the several situations, especially when certain countries are involved. The activism is still going on. Couples involved initiated different actions in different countries at the 8th of May, 2021. In Germany, they demonstrate in front of the Chancellor's building, whereas in France, they propose to post as much messages as possible on social media. So my second part is on some data. Who are these couples? We have for France, only for France, some interesting data who they are. So we have a first interesting survey initiated from a member of parliament called Anne Jeannette. She's representing French citizens established abroad. And she was really getting involved in that question and campaigned for unmarried couples separated by the COVID-19 crisis on her website. She received answers from more than 749 couples. So what can we say on this first survey? 70 couples are coming from 70 different countries. Most of them were couples with a French partner and a partner from the United States, 200, but also from Russia, Brazil, Morocco, and India. Foreign partners of French citizens came from a large range of countries, which are not the usual countries in French intermarriage statistics, except Morocco. Yeah. So 2 minutes, okay.
Thank you.
So the French branch of Love is No Tourism have about 7,700 members in their online group, and they have 2 surveys. I will do it very shortly. They show that they are 1 out of 2 foreign partners need a visa. 66% met 4 times before they get in before the crisis, and they are 1 out of 2 couples never lived officially together in France or abroad. They shared a common flat only for less than 7 months. They don't have, of course, all these papers. People ask them, the government asked them. The second survey showed that they are at least young people, 70% are students, and more than half of them met abroad, and a quarter of them on internet. Some conclusions. So from a sociological point of view, these couples are, most of them, in their first phase of conjugal life. This phase will last for more or less long period. It depends on the specific constraints of these couples. They need time to decide where they want to live, and how they will organize their common life regarding their job or educational situation, and also if they want to get married or not and when. So, but from a more, let's say, theoretical point of view, what we see is that the definition that their activism changed the definition of what a couple is. Being a couple does not any longer mean living together or being married. Being a couple is nowadays an ongoing process. These couples are in love. They have common experiences, common interests, and of course, common projects. But they only join occasionally and may live separately for more or less long periods. There is a process, I call it feeling in love process. The separation during the COVID-19 crisis was a big challenge for these couples. They were interrupted in their feeling in love process. This process needs to be ensured continuously about the common project. For that, their experience based on the alternating between being separated and being together is necessary. This alternating is an important movement to keep their feeling in love process alive. So during the COVID-19 crisis, some couples decide to marry. This crisis in a way accelerated the decision process. For others, however, the difficulties they had to afford make them decide to break up their relation. We cannot say it is because of travel ban, but at least a long-lasting separation, and the administrative difficulties make them take the decision against their couple. But in more general point, international mixed couples are not an exception anymore in our globalized world. Activism on social media help them to afford the situation and even to obtain some facilities. Some couples found solutions on a personal basis or by claiming their rights. Others stayed separated since spring 2020. Thank you very much.
Great, thank you very much, Beate, fabulous, for sharing with us these fresh information and giving us these premises of your theory, as we said. And now without undue delay, I wish to give the floor to Professor Daphne Hacker to make the comments. But before I present her, a few words. Professor Daphne Hacker is a legal scholar and a sociologist. She's a member of the Law Faculty and Faculty of Humanities at Tel Aviv University. She's currently heading the National Council of Jewish Women, Women and Gender Studies program. Her social legal research focuses on the intersection of law, families, and gender. Her latest book, published by Cambridge University Press in 2017, is titled Legalized Families in the Era of Bordered Globalization, and won the Best Book Award by the American Law and Society Association. Daphne, the floor is yours, please.
Thank you so much. Thank you, Professor De Hart and Professor Colette, for your brilliant presentations on cross-border couples' struggle to reunite during COVID-19 crisis. As I have told you both, the Love is Not Tourism movement caught my attention as well, as this is the most active and vocal movement of cross-border families affected by the crisis. The story of this young movement is fascinating and can teach us a lot about the interrelation between globalization, borders, families, and the law, which I've explored in the book that was mentioned by Imen. I came across this movement through its Israeli version, which to my understanding was the first to be established in May 2020. Its founder, Plia Katner, who is with us today, is an alumni of the Gender Studies program I'm currently heading and a member of the City Kfar Saba Council. And she established the Facebook page We Want to Meet Each Other in Hebrew for Israelis detached from their spouse or other family member abroad. It was she who directed my attention to the Love is Not Tourism page, established shortly after, mainly for EU citizens. As Professor Colette describes, the latter became an umbrella for more local struggles that focus on a specific jurisdiction. It is heartbreaking and inspiring to follow these pages. Stories of family members torn apart for months and months, struggling to be reunited. The most active group within the Love is Not Tourism movement are unmarried couples. As Professor Colette told us in her presentation, the stories reveal the lagging behind of national family law and immigration law in many countries. Within most jurisdictions, marriage and marriage among citizens is still the epitome of familial relations. They ignore the statistic indicating the death of marriage on the one hand and the globalization of dating on the other. In the US, for example, the marriage rate hit an all-time low in 2018 and dropped to 6.5 per thousand people compared to 16 in the 50s and 10 in the 80s. In Europe, the marriage rate is even lower and stands at 4.3 per 1,000 compared to 8 during the 60s. There are countries such as Iceland, Mexico, France, and Norway, in which more than 50% of children are born to unmarried mothers. This is less an expression of women choosing single motherhood, but rather the breakage of the link between marriage and parenthood, and the growing phenomena of couples establishing meaningful familial ties without marriage. The image of a national couple, meaning two adults who share the same citizenship and living in the same country, which still guides the social and legal imagination of many policymakers, is likewise outdated. In Switzerland, half of all marriages are binational, and this is also the case in 1 out of 9 marriages in Germany. Moreover, while many binational couples apply for naturalization for one of the partners in a bid to live together in the same nation state, some do not need to, as is the case with EU citizens, while others prefer or are forced to live apart together in different countries, maintaining the relationship virtually or through periodic physical meetings. Finally, as Professor De Hart explores, while many binational couples are relatively free in their ability to shape their relationship, others are less welcome and face increasingly harsh entry limitations, only heightened but not created by the current pandemic. Indeed, Professor De Hart rightly urges us to ask who is left out of the public discourse and public activism, who is completely ignored by the privileged mobile who are only temporarily immobile. As I have explored in my recent book, the laws surrounding families create hierarchies between those entitled to family life because they are wealthy enough or have the right skin color, and those who are dehumanized, among other means, through the desubjectification of them as familial beings. Professor De Hart highlights another important theme, which I also explored in my book when criticizing Beck and Beck-Gernsheim's Eurocentrism in their 2014 book on transnational families, the theme of love, which helps to recruit media and public sympathy, but ignores the cultures in which marriage is not based on love, but on other rationales. I would like to add one observation to Professor De Hart and Professor Colette's in that respect, and that is regarding the visibility of same-sex couples in the Love is Not Tourism movement. While many jurisdictions are also lagging behind a third characteristic of current couplehood, and that is that it is no longer only heteronormative, the Facebook pages portray many proud gay couples who refuse to accept their forced separation and reveal through their struggle against the pandemic regulations the homophobic and discriminatory nature of current family law and immigration law in many jurisdictions, which prohibit same-sex marriage and do not grant spousal visas for same-sex spouses. An additional observation relates to gender was made by Plia Katner, which I mentioned. Her experience taught her that most of the action taking place within the Love is Not Tourism movement is done by women. She explains to me during our correspondence, and I quote, "All the groups are connected, and we notice something very clear. In most groups, those who established and managed them are women. The men are willing to look at the wall until the sky opens." She goes on to suggest an explanation, and again I quote, "I think it has to do with the fact that usually the emotional maintenance of the relationship is on the woman's shoulder." When I mentioned that it is also clear from the post posted that women are much more involved in the movement, she agrees and adds, quote, "In many cases, the men were were the despaired and pessimistic party who did not believe that we will truly manage to change things. We, the women, were much stronger. Maybe it is not a coincidence that all the presenters in our workshop are women. Time and time again, in the conferences on family law and the sociology of the family, we see many more women compared to men. I see this as a sad reminder of the kind of hegemonic masculinity we're experiencing in late modernity, and wish to suggest a litmus test for a humane society. When we will see men struggling for the spousal relation and researching families, we will know the feminist struggle moved one step further. Plia's observation and the female dominance I see on these Facebook pages also echo, in my opinion, what we know more generally on the gender dimensions of the pandemic. As the statistics emerging from the pandemic on the labor market teach us, while women were preoccupied with their family responsibilities and ties, when men went on with their business, publishing more papers as academics, for example, than before the pandemic, while female academics publish less. Yet the action on these Facebook pages teach us also about women's resourcefulness as they share information, look for holes in regulations, ask for legal advice, and turn to courts, and use the virtual sphere to make their emotional labor visible, recognized, and acknowledged. Plia is an example of an extremely resourceful woman who went all the way to the Israeli Supreme Court to be allowed to join her spouse in Sweden, just to be later refused re-entry to her own country by the Israeli government that refused to let Israeli citizens who traveled for family or business back in, while at the same time allowing cross-border movement for religious reasons and tourism to the Arab Emirates with whom a peace agreement was signed during the crisis. This is just one example of the political interest involved in shaping the current plague governance that the marginalization of family ties within national and international politics and law. So whether cross-border unmarried couples were forgotten by the regulators, as suggested by Professor Colette, or intentionally ignored, as the Israeli example and those left behind discussed by Professor De Hart suggest, the current Love is Not Tourism legal, media, and public struggle expose the anachronistic understanding of what people who live in a global-bordered world and who seek a spouse need and deserve. Both the researchers we heard in this session call for family law and immigration law that acknowledge people's right to look for a spouse across borders. While Professor De Hart argues that the Love is Not Tourism campaign is not effective, Professor Colette argues it is. So this point is definitely in need of more investigation. The role of the law is an additional question waiting for further study. More generally, time will tell if the current crisis will ease borders or make them even harder to cross, and if people will increase their efforts to find a spouse across the border or will become more national in that respect as a backlash reaction to a world indifferent and even cruel to cross-border spousal relations. Thank you.
Great, Daphna, thank you. Thank you very much. So now I can already see a hand. The floor is open for your reactions and questions. And I start with Kinat Lahad. Kinat, please.
Oh, this is so great. I was clapping and I by mistake. Okay. No, but if the floor is mine, I will definitely use it.
It's yours.
This is hilarious. A typical Zoom occurrence. So thank you so much for these lovely presentations and amazing comment. I thought that the slogan, Love is Not Tourism, is really fascinating in the way it looks at love and the conjugal tie as a very stable kind of axiom in which when you are in a coupled relationship, you have to be in love and love conquers all and love takes place within the conjugal unit. And I was curious to ask also from the examples from France and Germany and Israel and the Netherlands or in other places, if the activist heard any kinds of critics about this focus on love. Daphna mentioned something which I found very interesting on the fact that it's a very Eurocentric, very Americanized kind of way of perceiving conjugal relationships and love relationships. But, you know, as feminist scholars have taught us for many years, love can be a very problematic emotion, which can be co-opted by patriarchy to dominate women. So I was wondering also in terms of how can we develop a feminist critique on this phenomena and how it is used in public discourse. So just a few thoughts and questions. Thank you.
Thank you, Kenneth. So please, I let either of the presenters or Daphna who feel concerned by the question to answer, please.
Do you want to address them one by one, or maybe collect a few? Yeah, you're the chair, so it's up to you.
I think maybe one by one, as we don't have a lot of questions for the moment. I just see the hand of Professor Ruth Halperin-Kadari. So I prefer that.
We have plenty of time, so we can do one by one. There's
okay.
Not rushing
so I think it's better one by one so that we don't get confused. So please, maybe Daphna, please.
Is Plia here? I think maybe she can answer about the criticism that the activists received or did not receive, because she's not only the Israeli activist, but also know about what's going on in other countries. But I don't know if she's still with us. Plia, are you here? I'll try and contact her in other ways, but maybe we'll hear what happened in other countries by our speakers.
Wait, did you call me? I'm
Hi.
here.
Plia, there was a question by Kinneret about criticism that activists in the Love is Not Tourism campaign received because of their emphasis on love and portraying, you know, love as the central piece in this puzzle, or other kinds of criticism. So I was wondering if you can enlighten us.
Again, can you please repeat on it? I hear you very like it's kind of problematic.
We are asking about criticism.
Criticism, yeah.
Yes, if criticism against the activism
of
love is not. It may be, you know, criticism on the focus on love as the entry ticket. What about those who are not in love? What about couples that their relations are not based on love? Maybe it's too romantic. Who's left out from the campaign? So I was wondering if you, as an activist, is aware of different kinds of criticism against this campaign.
I must say that while running the campaign, I didn't pay attention to criticizing like that you mentioned. I think that it more some of the people paid more attention if we are talking about the Israeli one. I pay attention that some couples who were married or were in let's say trying to get a citizenship in Israel, which I don't know how many people here know, but in Israel it's a very, very, very long procedure to get the citizenship for a foreigner person. So at the beginning, and it was a problem that I had to face with in the campaign, during the campaign. Some of them, I don't know if to say try to split from us, to make the group split to 2 and 3 even. They saw themselves like, I don't know if to say more important. And because like from my side, from my personal story, me and my partner, we are not married. And I always told them that I don't think that our love, or you cannot measure relationship, or you can not measure what's important more, or who is more important, like the one who are trying to get a citizenship, the one who live in 2 different countries but they have a certificate of marriage. You cannot measure it. And I think that from this side, I can say that I felt criticized by people. I must say that I didn't pay attention, for example, of people who, I don't know, want to cross the border because business, and then they criticize, I don't know, the reasons that we talk about love. I didn't feel it. Maybe other campaigns managers felt it, but I mostly felt it in the way that I said, like, it came like, who is more important, whose relationship is more important, or whose relationship is stronger, and who must get first the possibility to enter. And because I have history with managing campaigns like that, I know that the best thing to get results is to stay a bigger group as you can. And I always explain them, we must stay united, we must stay as one group and not start to split to smaller groups, because everyone then start, no, we are here, we were here before, we already started a process to get a citizenship, so maybe you should focus on us. And it was a I felt it criticized me during all the campaign, all the time, and yeah, it was very, very hard. But I think that it's also something that maybe in some way you can say that is unique for Israel, because there is a connection to the fact that to what we call mixed couples, but not because we are different nationalities, but more because we are what the state sees as different religions. It's harder in Israel to be a couple like that, and it's harder to get married. And I think that this is something that, for example, in Germany, I heard about the German researchers that are going to take place. I think that, for example, in Germany, they less feel it. So it's something, maybe it's unique to Israel.
Mm-hmm. Okay, thank you, Plia. Maybe Betty or Beate would have to tell us some reaction or answer to Kinneret or to Plia.
I have some ideas. Should I start, Betty, or do you want to start? So just let's say I would say love, of course, is not a critical issue, yeah, because it's a romantic issue, and it's usually used to get out of a political struggle theme. So this is more a general point. But in a way, this activism find a way to come over yes, they want to try to get a distinction to normal travelers, tourists, and they in a way show that people have these kind of conjugal arrangements, international conjugal arrangements, and their argument is love. So of course, when we look on feminist critics, thank you for the question, very interesting question. In general, I think they have, feminist critics are not so nice to couple life and conjugal life and love in a whole setting, not only for transporter marriages or transporter couples. So, of course, for me, in my way to deal with these questions is that couples, homosexual or heterosexual, international, national, they also always from a sociological or political anthropological point of view, they have inside differences and inequalities to overcome. And what they use is love to overcome these inequalities. So in a way, when we have a gender, when we have a critique theory with gender, we never can argue with love, of course. But in a way, love is what couple makes, well, in modern societies. Love is what couples use to defend their purpose, yeah. But how it is constructed, that's interesting for me, for these cross-border couples who do not live together and claim to join each other, is that what makes their love? How do they argue with their need to see each other? And what is their common basis to be a couple, you know? And then what is coming up for these kind of couples is they met somewhere, they felt in love, and they need to keep alive their love, feeling in love process. So that's all what they had for the moment. They don't have financial interests, I don't know, perhaps, but this is not their point. And I think the activism was a way to put it out of a more political struggle. Daphna is not does not agree with my point. Okay, fine. So this activism, love is not tourism, they intended to be out of the political struggle about legal restriction to immigration for marriage. Yeah. So thank you to Betty to put it in the discussion, because these restrictions, mixed couples, they are so much used to. Yeah, it's not a new thing. But so we don't want to have better conditions for all mixed couples. What we want is we want to go on and seeing us as before. Yeah, and then everybody goes back to its country. Yeah, it's not a struggle for intending to change the complicated political and law situation of mixed couples in the world. Yeah? Thank you.
Okay, Betty, please.
Well, thank you for these interesting questions, and for Beate for your presentation, and Daphna for your comments. They really make me think more about what I presented. About love, if we don't talk about love is tourism, I think what you are saying, Beate, is very interesting and relevant. So the campaign opted out of discussing family unification policies more generally. But if you think of this context, that not criticizing love or not claiming love is not an option, because then you're a marriage of convenience, and so then your application for family unification is rejected. So, and of course, it's a very problematic concept. And also, if you look at the practices of marriages of convenient control, they are very questionable in how the normative perception of what love is, because that is what they then do. So immigration officers looking for true love, basically, and the norms that they use there. But yeah, for those couples affected by that, claiming, well, love is a problematic concept. That's not an option, I think. That helps you anywhere, strategically speaking. The comment that this Love is Tourism campaign is done by women, I thought this was also very interesting. And this is something that you see, Beate mentioned the German organization, NGO Verband die Nationale Familien- und Partnerschaften, that was founded in 1972, so it's really, really old, long-standing. That was founded by women too, by German women. I think you see that in many organizations of mixed couples throughout Europe, at least, that they are started by women mainly, not completely, not exclusively, but mainly. And I suggest that as an additional or maybe alternative explanation, it's not only about women doing the emotional work, but also that women are mostly affected by family unification policies, as I suggested also in my talk. They are in a more disadvantaged position to meet the requirements. So that is why they, and also in the normative evaluations of mixed couples in general, outside of the even outside of the context of law necessarily, had comments by families, neighbors, etc., etc. They think of when I think of the last meeting that I witnessed, that was on Zoom of NGOs in Europe on mixed couples. It was also, I think, mainly women and 2 men. I think.
Okay, thank you, Betty. As I saw, there is an interesting discussion on the chat between Beate, Daphna, Ilaria. Also, she confirmed that on the relationship between love and feminism. So I think we can, as we have enough time, I would suggest that we maybe listen to the question of Professor Ruth Halperin-Kadari, and then move maybe to this issue of love and feminism.
Thank you. I think Sharon was before me. I noticed that she had her hand raised before I raised mine.
Okay, thank you very much.
It's fine, okay, go ahead. I'll be after. Go ahead.
Okay, whichever way you like. So thank you, Imen, and thank you so much, Beata, Betty, and Daphna, for fascinating presentations and comments. It's really makes your mind think in many, many directions. I have one, I think, rather short, pinpointed question, which could be characterized as maybe analytically, even doctrinally, to Beata, to Professor Colette, with your definition of mixed couples. If I noticed correctly, in one of the first slides, you included the situations of couples belonging to different ethnic groups or different religious communities within this broad definition of mixed couples, and you wanted to make the point to emphasize that mixed couples, in your view, is not necessarily cross-border couples. So I fully agree that that the discussion should not be limited to cross-border, to people who actually are physically present at one point in different sides of borders, and to also have included within this people in different statuses, different migration statuses within this discussion. But I find it difficult to include in this couples belonging to different religions. I find it especially difficult coming from our own experiences in Israel, which Plia also pointed out, to the specificity of the obvious lack of civil marriages, and in fact the impossibility of mixed marriages in the sense of interfaith, interreligious marriages in Israel. But I also find it difficult from the position of EU countries, especially let's take France, laïcité, which in fact erases completely, at least officially, formally. I'm not saying culturally. I mean, sociologically, I'm well aware that the differences are totally there, but legally, formally, officially, the religious affiliation is completely erased. So, what relevance is there to these affiliations, and how does it? I mean, I'm just wondering, what is the reason for your insistence on including these situations in your broad thesis?
So thank you very much for this question on my, do you hear me? Yeah, on my conceptual frame, let's say. Of course, there are different situations, different configuration of couples. Cross-border as one, which is of course specific. But when we look on the whole huge amount of studies which have been done on mixed couples or international couples, interethnic couples, and so on, we have a lot of work coming from the US and concerning Black and white couples inside the MEM society, inside the same society. So, and the first sociological work on mixed couples in the 40s, in theoretical work in the 40s, insisted on the disapproval of social groups against these marriages. And I go out from that point that even if there is laicity in France, there is a lot of disapproval, a lot of discrimination towards interreligious marriages from inside the religious groups and from outside, yeah, from both sides, not always from both sides. So it might be the Catholic group against marriages with Muslims or with Jews, and it might be from the society, when the society comes up with arguments that, oh, how will you deal with the two religions? How will you do with your children? And even if France is, let's say, officially a laicist country, people they have faith and they have religious belongings, yeah, inside the country. Laistic principle is only there, I would say, to make the cohabitation possible inside the same country. We don't have a state religion, which makes it different from Israel, yeah? So, but look, for instance, also on all these migrant descent people in our multicultural societies. They have a sense of belonging to a cultural group, and they have specific cultural demands. And yeah, they are not completely accepted as French or German citizens in the country. And of course they are not so much in Germany, but in France we have now a huge part of the population which are French people, but almost 30% of the whole French population is of immigrant descent now. Yeah. So, but they are French. Yeah. 20% out of these 30% are French people. So this might be the same in the Netherlands. So it's difficult for me, for a general frame, to put them out and to limit a definition only on cross-border marriages. And the second point is that religion only in very few situations, or race only in very few situations, comes alone. Oftenly religion is linked to culture, is linked to nationality, and it's crossing, yeah. So that's why I choose the word mixed and not interethnic, because the interethnic, interreligious, are international, and so you know, that's also another point. Only in some situations, faith stands alone. Culture never stands alone. Culture is always a question of culture, religion, and nationality never stands alone also, yeah? So that's why I prefer this kind of framing. But of course, when we're doing empirical work, we will not work on all these couples on the same time. We will choose specific configuration, but we should try to put them in a general frame and to look what is specific on that configuration compared to the others. Thank you.
Okay. Betty, do you have also something to say about
yeah, I
group?
That's with Beate. So, and I only want to add, I think that it is not about what people are, it is about how the social environment sees them. So many mixed couples that we call mixed may not even consider themselves mixed. And I had one of my postdocs working on interviews with what we call interracialized couples, also to make clear that this is not about what people are, but how they are seen by their environment. And many of them rejected the label of being mixed. Somebody is talking.
Yes.
So many rejected this label of being mixed. So it is, yeah, it is not about what people are, but about how they are seen by their social environment. And this differs in times and place. So it can be that a couple, the same couple, is considered being mixed in one place, and then in another place, like 200 kilometers further, not considered mixed because the social environment and context is different, and political context, it's also, of course, politicized. And it's the same in time. So for instance, in the Netherlands, in the 1960s, Dutch-Italian couples, it was Dutch women with Italian men, were very much problematized. And I think nowadays not so much. So they would not necessarily be considered mixed nowadays, but they were definitely in the 1960s. So also in time and place, it differs. So it is, yeah, that's only what I want to add. And
yeah, thank you, Betty. That's why I think we lawyers, we need sociologists. Otherwise, our work is really very limping. So we need you, for sure. Sharon, please. And then
thanks. Thank you, everybody, for a very interesting panel. Sorry. So I think I was very happy with having two papers about love and tourism, and thinking about it. I'm thinking, and I have my question is critical, but by no means judgmental. So I'm asking whether this campaign is a missed opportunity for a few reasons. So the first one, I thought Keynote was pushing there. Love is not just marriage, and marriage is not just love. Love is many other relationships. It could be other relationships which the law ignores completely, such as siblings, such as adult children and their parents, such all kinds of relationships. And obviously it is not just about, a very young, very white, very Eurocentric couple who wants their love recognized. And so that's the first possible miss. And the second possible miss is when sometimes you have a very buzzy, cool struggle and it works. And then, so that I sometimes think that Corona was an opportunity for the rest of the world to come on board on the problems of international families. And now you have this love is not tourism, and then you solve the problem and everybody thinks everything is great. And I think people who think about this subject know that it is very far from being great. So I'm thinking maybe this kind of campaign is a missed opportunity in these two ways. And I'd love to hear if you have any thoughts about that. Thank you.
Please feel free. Our presenters.
Shall I start? Yeah, then you can pick it up. Yeah, thank you for your question. I want to first, before I answer your question specifically, I want to, I do not want to underestimate the problems that these couples have been facing. I also have, so I don't want to reject this campaign altogether. They have every right to campaign, and rightfully so. Nevertheless, I agree with you. I think, yes, that's my concern also. And as I said, also, not only for this specific campaign, but also for other campaigns, I think there are different other ways of doing this. And I think there are also examples of that. And when Beate was talking, I wondered, so to what extent my talk is really about the Dutch context. I'm not sure, maybe not, but maybe there's also something specific going on for the Dutch context. There are examples also with the Dutch context of more effective campaigns where coalitions were being built, and so more fundamental issues could be addressed. For instance, there were very high fees for residence permits, were really extreme. Like in the UK, they still have them. It's like thousands and thousands just for getting the residence permit, the fee that you have to pay. This was ended by the European Court of Justice, this policy. And this was the effect of a campaign of different organizations that pulled their resources in terms of people and money to be able to have a political lobby campaign. So organizations of mixed couples, of migrants, of Dutch immigrants, of expats, all of them coming together and doing this political campaign that turned out to be ineffective and then turned into the European Court. Well, unintentionally, by the way, because it was a judge who asked the question to the European Court of Justice, but nevertheless, and then the court ended this policy. So I think that is one example of an effective campaign where you see this, building coalitions that can address issues in a much more fundamental way, I think. And of course, what you're saying about that love is about many forms of relationships and not only about these couples. Yes, of course. I must say that the Dutch campaign I saw recently also turned to claiming that they wanted their parents to be able to visit. So that addresses your issue. And I think that was really interesting. And of course, also outside times of COVID and for the silent transnational families that I talked about, having your parents visited has been a really problematic issue for a long time. Let alone letting them reside with you, but just even for short visit, if there's a visa obligation, that has been a huge problem already for a long time in the Netherlands.
Sorry, Betty, sorry, it's really very embarrassing for me to interrupt you, but we still have 4 minutes or 5 minutes at the most. It's a very embarrassing question, you know, the one of the chair, but I have to. And we still have the maybe the reaction of Beate and then the question of Plia, but we have really to end in maximum in 4 minutes. So please try to be concise as possible. And sorry again, Betty.
No problem.
Thank you. Beate, please, and then the question of Plia.
I just would say one point. I was interested in this activism because when I look to work on to studies which have been done on mixed couples and cross-border couples, I did not see these ones. The ones who did not live together in the same place. I did not see work on these couples. And that was the interest for me. They in a way, it's perhaps not enough, a missed opportunity, but in a way, we get aware of an existing new feature that people may live in separated countries and feel like a couple. Yeah, and we did not see them in studies before. That was my interest in them. And I think I will continue with these couples to try to get out how they meet and on what basis they think they are a couple, because for me, that's what I put in the conclusion is the definition of couple is shaping. Yeah, it's not anymore official thing with marriage and things like that. Thank you.
Okay, thank you very much. Plia, please, you have 2 minutes.
Yeah, I will make it really short. It's not a question. I just want to say, like, some of you say things and then it, like, some things pop up in my mind. And I heard what Sharon said about a lot of kind of relationship that we can say love, like siblings, like parents and children, and etc. etc. And then I thought maybe this is what Daphne meant when she asked me about criticize according to the campaign. So I must say that there was something special during our campaign, that we actually kind of discovered a new law in Israel. It's actually an old law from the 60s, I think, that say that children for Israelis who live abroad must be written as citizens of Israel. And a lot of people didn't do it, and Israel kind of didn't pay attention or didn't care until the corona and the closing of the borders. Nobody say anything, and those children, for example, or any kind, I don't know, siblings, they enter to Israel with a foreign passport. And then when the corona started, actually Israel saw them as foreigners. So of course we fought also for those people, but because there is a law about the thing, we couldn't put it inside our campaign exactly, because this is something different. To change a law or to change a regime, it's something different, okay? One you can do in the Supreme Court, during the Supreme Court you can change it, and the other one you can change only by the parliament. And changing things during the parliament is much more longer process. Now there is now a campaign that started for this thing, but it will take time. I don't see how it will happen in the near future. But I can say that I'm glad to say that they didn't criticize us for working for couples. Most of them I understood that like the differences after we explained them, like the technical differences. And another small thing about what Beata said, that the couples black and white, or Catholic, or etc., etc. That's right. But in Israel, the difference is that in Israel, the regime doesn't let you get married with somebody else. In the US, if you are black, you can marry to a white person. Even if somebody will criticize you, there is a possibility. In Israel, we don't have the possibility. I can get married with only somebody who is written as a Jewish person. And my partner, when I told him, he discovered through me that he's Christian. He was in shock because he's very secular and he doesn't see himself as a Christian. But according to Israel, this is what he is. And that's why we can get married. And this is the difference. So that's all.
Thank you very much, all of you. It's really great, very, very inspiring. I mean, we have not answered questions now. We just wrote new ones, and you will have the whole year and for now the whole session to think more about them and about other issues of our topic. Thank you all, and we will meet again at Daphne, or I give you the floor. You do that.
I don't want to say the exact time because each of us is living in a different time zone. So we are having 15 minutes. Do not zoom out. Just close your cameras. 15 minutes, coffee, something to refresh yourself, and we're back to do 2 additional wonderful sessions. Thank you so much for the first session speakers.
Thank you. Thank you all.
Thank you.
Thank you.
Good afternoon, everyone, or good evening, or good morning, I suppose, to some. Excuse me. We're going to be looking at issues related to child abduction with Professor Rona Schutz, and then cross-border childbirth with Nofa Yokavi Gan Or. I've switched the order around because Professor Schutz needs to get away a little early. So what we're going to do is have Rona's contribution followed by comments from Maxine Eigner, and then a little bit of time for question and answer, and then move on to Nofar's presentation, comments from Professor Zvi Treger, and then hopefully a little bit of time for question and answer at the end. Excuse me. So let me introduce Professor Schutz, who is Professor of Law and co-director for the Center for the Rights of the Child and the Family at the Academic College of Law and Science in Israel. She's also an adjunct professor at Bar Ilan University in Israel. And before migrating to Israel in 1993, Rona was a lecturer in law at the London School of Economics. She's written extensively on international family law, notably her leading monograph on the Hague Child Abduction Convention, published by Hart in 2013. And there's probably nobody better to speak really on this topic of the effect of COVID-19 on the Hague Child Abduction Convention. So over to you, Rona.
Hello, everybody. First of all, I'd like to thank the organisers of this conference for this fascinating workshop and an opportunity to see and hear old faces, including my colleagues in Israel who I haven't seen for over a year, and colleagues from abroad, and also faces behind names of well-known articles and literature. And thank you, Paul, for your introduction. Whilst the COVID-19 pandemic has created challenges for all judicial proceedings concerning children, the intrinsic nature of Hague Child Abduction Convention proceedings makes these challenges particularly acute. In the first part of the paper, I will briefly survey the response of courts and other relevant authorities in some states, those for which I was able to get some information, to the above challenges. And the second part of the paper will focus on the Article 13(1)(b) grave risk exception, which Yuko mentioned in her introduction today. I suggest that we can use the COVID-19 crisis as a vehicle for analysing the concept of grave risk, what do we mean by grave risk, and the application of the exception. On the basis of my research so far, which is largely based on decided case law and also very helpful conversation in a lawyer at the Israeli Central Authority, Advocate Leslie Kaufman. I saw that she joined before. I don't know if she was still there now, but it was very helpful conversation with her. So on the basis of that research, it seems that the Abduction Convention did continue to operate effectively in many states. And the available statistics suggest, perhaps surprisingly in my view, that there was only a modest reduction in the number of abduction applications and returns, at least in Israel and the States, in the US, which is the countries for which I was able to get statistics. You'll see here that I in relation to Israel, I've got the number of applications for 2018, 2019, 2020, and you'll see there is some reduction, more in the outgoing applications than in the ingoing ones, but not such a huge reduction. And in the last column, if you look at the number of returns to the US from convention states, which I took from the yearly State Department reports, you'll see again that the reduction was only relatively modest. Not certainly I would have expected a larger reduction. Of course, the picture might be different in states where the pandemic was worse. And of course, maybe 2021 things will be different, we'll see, although as travel restrictions have possibly been less, maybe not. In many countries, expedited hearings still took place via digital platforms, and return orders were made and executed, although in some cases, courts did order that return would be delayed in the light of travel restrictions. But from what I understand, in most cases, the returns did eventually take place, even if there were delays. Central authorities and other administrative authorities did help to try and overcome logistical problems, such as where there were few flights, they managed to get priority in getting airline tickets, and also priority in getting places to stay in those countries which required incoming passengers to stay in quarantine facilities. However, in some countries, COVID-19 did cause delays in hearing cases. And in one UK case, the difficulty of obtaining within a reasonable timescale information from Brazil concerning the enforceability of protective measures resulted in a non-return order. Okay, there was also a case about barriers to physical contact, where a left behind parent wants to actually come and visit the child prior to the actual hearing into the convention, which of course normally wouldn't be difficult at all. And there's a UK case where the parent tried to ask for an exemption from quarantine facilities, but quarantine restrictions, but that was refused. Okay, now onto the grave risk exception. For those who aren't familiar with the convention, I've actually set out here the provisions of Article 13(1)(b), which allows the court to refuse a return where there is a grave risk that his or her return, referring to the child, would expose the child to physical or psychological harm or otherwise place the child in an intolerable situation. I only found a few reported cases in which the taking parent argued that the grave risk exception should be invoked because of COVID-19. And most of these cases were at the beginning of the pandemic, where the abduction had taken place earlier, in other words, before the pandemic. One reason for this might be that a parent might be in some difficulty to try and argue that because of the pandemic, it's dangerous to travel now, when he himself had actually traveled during the pandemic when he abducted the child. how in all the cases where the claim was made, which were reported, it was rejected. In most of the cases, the court focused on the fact that it was not proven that the risk of infection was any greater in the requesting state. And sometimes the opposite. There were cases where the court said, well, actually, in the state you came from, there's less infection there. But the courts did not specifically refer to the risks involved in air travel, which might be quite surprising given the fact that it was known that people did get infected with COVID-19 on aeroplanes. Where are we? Okay. However, in some cases, as I mentioned before, the court did order that execution of the return order be delayed until practicable. In other words, didn't give a specific date. And in some cases, until further submissions. In other words, the court realized that it could be a while. And in one case, for example, the court said, as soon as it is safe to travel. And in addition, I found 2 cases in which return was refused for other reasons because a different exception was established, or one of the threshold conditions wasn't met, in which the court did say that if it had to order return, it would not have done so without further submissions concerning the impact of COVID-19. And there was a clear suggestion here that the court might have been willing to invoke the grave risk exception in those cases. And I also found one case in which the court specifically said in exercising its discretion to not to return the child when the acquiescence exception had been made out, one of the reasons was the risk of being infected during a long international flight. The question of whether and in what circumstances a pandemic might establish the grave risk exception, which I don't think any of the courts really dealt with in a systematic way, involves a number of issues that have arisen in case law in relation to the application of the exception in other contexts. So it seems to me that a discussion of the issues in the COVID-19 context might produce insights relevant to other contexts in which the grave risk exception is invoked, and especially the unfortunately not uncommon situation where the taking parent has suffered domestic violence at the hands of the left behind parent. The increase in reported incidents of domestic violence since the beginning of the pandemic means that the debate surrounding these issues in the domestic violence scenario is unfortunately likely to be even more pertinent in the near future. So here's a list of the main issues which I think arise in considering whether the grave risk exception is established in a case during the pandemic when it's claimed that returning the child would give risk of him contracting COVID-19. And I will look at each of these, at least so far as time allows. But just before I start considering each of these issues in turn, I just want to say a few words about the general approach to interpreting the grave risk exception, especially for those who are perhaps not so familiar with the convention. The general approach of the courts has been that the exception should be interpreted restrictively to avoid undermining the convention. And this approach is supported by the Guide to Good Practice on Article 13.1b, which was finally published, perhaps ironically, just before, right at the very beginning of the pandemic, after many years of work by a large working group and other actors in the Hague Conference. On the other hand, it's important to point out the critics of over-restrictive interpretation, and I am among them, argue a number of things, why we should be careful not to interpret the exception too restrictively. First, we have to remember the primary objective of the convention, as is stated in the preamble, is to protect children from the harmful effect of wrongful removal and retention. I'm sorry, that word says return instead of retention. Maybe this was a Freudian slip. It's supposed to say retention. Okay, if the return causes the child harm, the presumption that return promotes his best interest is rebutted. And that presumption, that return promotes the best interest of the child, we have to remember that is based on the drafter's original assumption about the typical abduction scenario. For those who are not familiar with this, the drafters assumed that the typical abduction scenario was where a non-custodial father took the child away because he lost custody or out of revenge or something else. But in fact, today we know that in the vast majority of cases, more than 73%, the abductor is the mother, and in over 83% of cases, the abducting parent is actually the primary carer and not a non-custodial parent. Okay, so I think when we look at how to interpret the exceptions, we have to remember that the assumptions behind the original convention are not valid in most cases today. Okay, and in fact, the drafters saw the exceptions as part of the policy of the convention. Okay, they're exceptions, but they do reflect the drafters' view that in these cases, then return should not be ordered because we are concerned about the safety and well-being of children. Okay, now to the issues. First of all, the method of assessment. How does the court decide whether a particular potential harm actually meets the grave risk threshold? Okay, now, the leading case, I think it's the leading case, at least in the UK, and it's been widely quoted in many of the jurisdictions, RE, makes a number of points. First of all, it says that the alleged harm must be intolerable and that there is a link between the word grave, which qualifies risk, and the word harm. Now, if we put all that together, then basically, in order to determine whether the exception is established, it appears necessary to assess three things. First of all, whether the alleged harm would be intolerable if it actually crystallized. Two, what is the statistical likelihood of the alleged harm occurring? And three, whether this is sufficient to be defined as a grave risk in the light of the level of the harm. Now, it will be apparent that whilst in some cases the second test of the likelihood could be based on objective statistics, there are no objective tools for making the other assessments. There is no objective way of determining whether a particular harm is intolerable. And there is no objective way in determining whether a particular percentage actually constitutes grave risk or not. In other words, at the end of the day, this is a highly subjective assessment. And I think that the COVID scenario demonstrates well the difficulty of assessing grave risk in the absence of information, accurate information, and the subjectivity. For example, in some of the cases where the court said that there wasn't a grave risk, they worked on the basis that children are not seriously affected by COVID, children not a high-risk category. But in fact, it's been shown afterwards that the reports that significant numbers of children were suffering from post-COVID chronic symptoms, some of them serious. Also, I think the COVID pandemic has illustrated widely varying views as to what degree of risk is acceptable. We can see this both at governmental level and at the individual level. Certainly in Israel, and I suspect in other countries as well, there were large differences. There was a parliamentary committee in Israel which had to decide what restrictions should be imposed and when they should be lifted. And there were forever continuing arguments among the various members of this committee. And also on an individual level, I've certainly noticed among people that I know that there's a huge difference as to what degree of risk is considered to be acceptable, what activities, can we have the grandchildren to stay, can't we have the grandchildren to stay? I'm not talking about externally imposed restrictions, I'm talking about individual views. And that's even people who are themselves in high-risk views, high-risk groups. More generally, the COVID pandemic has brought to the fore the science of risk exception, with various models being developed to forecast the likely spread of the disease. Leading researchers in this field have expressed the view that in the light of unavoidable uncertainties, scientific predictions can only be one ingredient in decision making, which should include additional policy dimensions. They also advocate the precautionary principle, according to which if the consequences of an activity could be serious and subject to scientific uncertainties, then precautionary measures should be taken or the activity should not be carried out. Okay, so I think we can draw some conclusions from all this in relation to the assessment of grave risk. First of all, I think it's important that courts should provide you with relevant scientific information in relation to risk. For example, in the domestic violence scenario, information about the dynamics of domestic violence and the effect of exposure to violence on children. In the first draft of the Guide to Good Practice, there was a very helpful appendix summarizing the research on those issues. In my view, unfortunately, this was omitted from the final version. Secondly, I suggest that intolerability should include a normative element, given the limited possibility of predicting levels of risk and harm objectively. And therefore, it should include considerations such as the fact that the risk was created by the left behind parent himself. He's the one that was violent, and therefore he's created the risk. I think that should be one of the considerations to be taken into account. And in additional national and international policies designed to combat domestic violence. Okay, today we see very few, if any, signs of that sort of discourse in cases involving discussion of grave risk in the domestic violence situation. Okay, on to the second point. What is the relevance of the likelihood that the grave risk will cease to exist? Now, this, of course, was a situation in the COVID cases. It was assumed that even if there was a grave risk of return now, then it would surely pass. And it appears that the appropriate response is indeed that the courts took, which is to delay return until after the risk has passed. And in fact, I will just mention that Brussels 2 bis actually recast actually provides expressly that enforcement proceedings can be suspended where there is a grave risk. In other words, after return has already been ordered, then the proceedings, the actual enforcement can be suspended. But the question arises, which seems to have been perhaps ignored, is how long for? How long is it appropriate to delay return for because there's a grave risk? We know that the COVID crisis is it's a lot better in some countries now, but there's still some countries where the pandemic is still going strong, unfortunately. Enforcement of return after long periods of time of more than a year, for example, can hardly be described as prompt return. And just to mention, there was one case where the court actually suggested that if there was a really long delay, then the order could be discharged. But we perhaps might need to think of what period of time would be a maximum in this context. Third point, burden of proof. What is the burden of proof of the abductor who is claiming that return will give rise to a grave risk of harm? The convention is silent on it. The US legislation adopts higher standard for the grave risk exception of clear and convincing evidence rather than the usual balance of probabilities. Here I just want to mention the Israeli courts who, for reasons which I still can't fathom, have adopted a burden of proof of beyond all reasonable doubt. In other words, the criminal burden. It seems that some court mentioned this and it's just been adopted by all subsequent courts who have discussed it. And just as an example of that, there was one case during COVID involving return to France. The parents maybe didn't get such good advice at first, and that first instance didn't plead the grave risk exception, and then he changed lawyers, and the lawyers then on appeal said yes, that we should claim the grave risk exception. In France, the pandemic was much worse than it was in Israel at the time, but the Supreme Court simply said we're not even going to allow you leave to appeal, A, because you didn't plead it before, and B, because you could not possibly prove the grave risk exception beyond all reasonable doubt. I think it'll be apparent that such a burden of proof almost makes the exception redundant. Who is ever going to be able to prove grave risk beyond all reasonable doubt? Unfortunately, no stance about the burden of proof was adopted in the Good Practice Guide, even though I did send them comments and ask them to make some comments at least about the mistaken Israeli legislation, but they didn't, probably for political reasons. And the conclusion is that since exceptions are part of the policy of the convention, there is no basis for a burden higher than the usual civil burden of balance of probabilities. Otherwise, it's going to make, in many situations at least, the possibility of establishing the convention almost impossible. Okay, the next point is the relevance of the risk to a risk to the taking parent. Imagine a situation where the taking parent is, and who's also a primary carer and got a young child. He's in a high risk group. He has some illness, and he is in a high risk that if he is infected by COVID-19, he is very likely to be seriously ill or to die. Would this be sufficient to establish the grave risk exception? Now, it's now widely recognized that the exception can be established where there's a risk to the parent, and that will have an impact on the child. Okay, there have been disputes about this, and there were cases that said no, it has to be a risk directly to the child. But now I think it's widely recognized that in theory, at least, it would be sufficient if you can show that there's a risk to the parent, but that will have an impact on the child. But there's still a lack of clarity. In other words, it wasn't good enough that there was a risk that the child would be exposed to violence in the future. So there's still a lack of clarity about this situation, which needs to be sorted out. And my conclusion would be that it should be possible to establish the exception, at least in cases of young children, where the primary carer cannot accompany the child or cannot reasonably be expected to do so. And the risk of violence, serious violence, should be a good reason not to, it can't be expected to return to risk of violence. Given the research that we have, it does show that returning parents have been subjected to violence, one awful case where a returning parent was murdered, etc. I will just perhaps add that there is some support for this, my conclusion here. There are some cases where return was postponed or refused because the taking parent was not able to return because she was undergoing medical treatment or was not able to enter the requesting state for immigration reasons. Okay, and now the fifth point, can protective measures mitigate the risk? Now, the use of protective measures, usually in the form of undertakings given by the left behind parents or conditions to return made by the court, has become quite widespread. These measures are designed to mitigate the risk of harm to which children would otherwise be exposed on return and thus prevent the exception from being established. The main criticism levelled against the use of these measures is that they are often not adequate to protect the child, largely because they are not enforceable. Now, in the COVID context, we might ask whether undertakings by the left behind parent to abide by social distancing or to remain in an area with a lower risk of infection will be sufficient to mitigate the risk. My view would be that the answer to that is negative, because you simply cannot enforce what the left behind parent is going to do. I mean, we can think of protective measures which might help the child join the flight. We might say that the child can only go on a flight where everybody's been tested or something like that. But if we're talking about measures which are supposed to prevent the child from catching COVID after return, then undertakings by the left behind parent would seem to me to not be sufficient. And of course, given the dynamics of the infection, an area which had low risk yesterday may have high risk tomorrow. And I think a general conclusion might be that protective measures relating to future behaviour of the left behind parents should not be considered adequate unless that parent brings clear evidence to show that they are in fact enforceable. So if I can summarize, from the information that I have at the moment, and of course there may be other information which I haven't yet managed to find, the COVID-19 pandemic does not seem to have had a significant impact on the operation of the Child Abduction Convention. However, it does provide us with a lens through which to reconsider some of the issues which arise in relation to the grave risk exception, which will continue to be relevant long after the pandemic is over. Thank you for listening.
Thank you very much indeed, Rona, for that very clear presentation. And I want to introduce our commentator on your presentation, Professor Maxine Eichner, who is the Graham Keenan Distinguished Professor of Law at the University of North Carolina School of Law in the US. She is author of The Free Market Family, How the Market Crushed the American Dream and How It Can Be Restored, OUP 2020, which won the 2021 Prose Award for the best scholarly work on economics. And she's also the author of The Supportive State, Families, Government, and America's Political Ideals, also by OUP back in 2010. Obviously, she's authored many other works. She is a law and arts graduate from Yale, and she has an MA and PhD in political theory from the University of North Carolina, and she will give us her commentary on the topic that Rona has just been speaking on. Thank you, Maxine.
Thank you so much. Can you all hear me? Yeah, okay. And Professor Shoes, it is an honor to be talking about your work on the Hague Convention. In this talk, I want to draw not just from what you just said, Professor Shoes, but your other work on the Hague Convention and specifically your recent International Journal of Law, Policy and the Family article, the Hague Child Abduction Convention and what you call relocation disputes, which I just love. In that article, as with your talk, you focus on a situation that the framers of the Hague Convention didn't anticipate. As you said, they anticipated a particular kind of dispute in which the non-primary caretaker, which the father abducts a child and brings the child to another country. And as you point out, most cases that are brought under the Hague Convention actually don't follow that pattern. Far more involve a situation in which a primary caretaker, usually the mother, takes the child. In your article, you talk about the situation, well, here you talk about a situation that the Hague Convention framers certainly wouldn't have contemplated, a major international pandemic. In your article, you talk about these relocation disputes in which a couple moves to another country, either conditionally on both liking them or temporarily. One member of the couple decides they want to return home. And then the question is, do the Hague Convention protections kick in? Both in this talk today and in your article, I thought it was particularly important and valuable that you did two things. First, you crystallized a clear-eyed recognition of the way that these situations we are confronting today weren't intended by the Hague framers, and in many senses really are a poor fit to the rules that the framers crafted. So that in the situation of relocation disputes, the analysis of courts turn on where a child's habitual residence is in situations in which a child may have deep ties to both countries. And the situation of whether a child is, well, the issue of whether a child is being removed from a habitual residence really doesn't answer the question of whether the child needs the kind of protections that the Hague Convention contemplates. But then you move beyond that valuable project of showing what a poor fit in many ways the Hague Convention is to these situations. And you do your best to explain how, even given those problematic protections, courts and lawyers can do justice to the goals of both the Hague Convention and the best interests of the child, which of course is a major goal of the framers of the Hague Convention. In thinking about what those goals are and how we can best effectuate children's interests, and taking up the topic here today of transnational children and transnational parenting, there was one thing that you said in your article that really stuck out to me. And that comes up when you were talking about the situation in which there are children born in a family in what we could call the base state. And the parents move temporarily or conditionally, and another child is born. If one of the parents then wants to return to the base state, under the Hague Convention, we get a set of problematic results, because the older kid's habitual residence might be that initial base state, but that's not going to be true of the younger child. And you say in that situation, trying to do justice to the kid's best interests, given that the baby's real connections will be with his parents and siblings and not the country itself, there surely can't be any justification for separating the baby from his siblings and parent. What that made me step back and think about was how that statement actually is true, not just for the babies, it's true for all kids, or certainly all young kids. And that is, the kids' real connections are with their parents and siblings and any other close caretaking or sibling relationships that they have. But the Hague Convention makes us focus on the geography, the child's connection to place, rather than the child's connection to people. And everything we know about young children's well-being shows that, assuming they are getting certain basic features of their life covered, they have enough to eat, they have a stable roof over their head, the most important factor in a child's well-being is going to be their relationships with either their primary caretaker or caretakers if there's more than one. In the typical situation of the Hague Convention, that the framers contemplated a situation in which the non-primary caretaker takes the child away. In focusing on the child's habitual residence, it doesn't make a difference in terms of whether we're focused on place or whether we're focused on relationships, because in that situation, the child is being returned to the primary caretaker. But once we move away from that typical situation, as in the situation of relocation disputes or the other situation you talked about where the primary caretaker is the person to remove the child. And as you point out, that is in most situations in which the Hague Convention operates. In that situation, we have the Hague Convention pointing us probably to less relevant features of the child in terms of the child's well-being, rather than those most important features of the child's primary relationships. I think what your work, the one place your work helps then is in looking at how we can shoehorn what courts, well, what the Hague Convention framers considered the habitual residence analysis. We can shoehorn into that analysis as that analysis has emerged. And you said a kind of hybrid analysis has emerged in at least many countries. That hybrid analysis looks at the child's connection with the place, but also the child's connection with people. And it's there we have to push courts to focus on those primary connections, and also focus on, because we know the quality of caretaking depends on the well-being of those primary caretakers. We've got to be pushing courts to focus on that first and foremost. Now, of course, the Hague Convention was created 40 years ago at a time in which we thought children generally will only have one primary caretaker. These days, of course, that's not always the case. And of course, it is increasingly a situation that's not the case, and a situation in which we want to foster for a number of reasons, including the child's best interest to have connections with both parents or with another close caretaker. And of course, we want to foster those kind of connections as well because of gender equality. In that case, once again, in cases in which children have more than one primary caretaker, courts need to be focused on the best interests of the child in terms of looking at the place that will give them that close connection to both caretakers, and in a manner in which, or more than two caretakers, and in a manner in which those caretakers have the best chance at their own well-being, and therefore to foster the well-being of the child. I'll stop there. Thanks.
Thank you, Maxine, for that very interesting and helpful presentation. I'm going to abuse the chair for a minute while people think of their questions, and I'll bring people in for questions. Yeah, I must defend the framers because they get a lot of abuse, and I love the framers. One of them was my mentor, Sandy Anton. Yeah, one of them was Elizabeth Perez Vera from Spain.
Paul, you know this was nothing personal, right?
Oh, I realize that, but I want to say that they are perfectly well aware it wouldn't just be non-primary carer abductors. They thought that was the typical case, but they were well aware that there would be primary care abductors, and everybody who says they weren't is not speaking the truth. They were aware. And they were also aware of the growing trend towards joint custody, even as early as the 1970s. These were prescient people, very clever, very prescient people. And frankly, they did a fantastic job in producing a convention which still works today, and we can make work today even in changed sociological circumstances because they produce such a subtle convention. And it is subtle because it has an automatic return at the heart, on the basis that, of course, the courts of the habitual residence of the child are perfectly well capable of discussing all these things about what's in the long-term best interests of the children, because the Child Abduction Convention decision is not a final decision, it's an interim decision. It's a decision on where the merits should be decided. That's its primary purpose. And that's why the exceptions are exceptional. You only bring them in when you need to override the right of the court of the habitual residence of the child to make those long-term decisions. And of course, domestic violence is one of those cases. And of course, if there's a short-term COVID problem which actually makes a big difference to that particular child, again, it would be one of those cases. And the flexibility of those exceptions to include, by the way, discussions about siblings, which is, there's loads and loads of cases where courts have discussed and not returning a particular child because that would divorce them from their siblings. So if you've got these families, and there's plenty of them, where you have older children who don't want to go back, and they've made that clear under Article 13, paragraph 2, the younger children aren't always automatically sent back, because judges are smart enough to realize that a reason for not sending them might be that it's inappropriate to split the siblings. So, I mean, your points are good, but the convention allows judges to exercise quite a lot of discretion to deal with the more difficult cases, when in fact, still today, the vast majority of cases are actually easy cases. And we mustn't lose sight of that. Still today, most cases, the abduction is not justified. That's the reality. And even sociological studies will support that, but that is the reality. We mustn't run away with the idea that the vast majority of primary care mothers are fleeing domestic violence. They're not. That is not the reality. Anyway, I shall now give other people an opportunity to give comments. I've got somebody from the Justice Department. I can't work out the name from the shorthand. LESLIEK at justice.gov.il. You have the floor.
Okay,
you have your hand up. Yes, thank you.
I'm on mute.
No, I hear you.
Oh, you can hear me.
Yes.
Hi. Okay. Yes, my name is Leslie Kaufman. I'm with the Central Authority. I'm sorry, I'm having trouble with my video. I don't think my camera's turned on. I just wanted to relate to a few things. First of all, there was quite a bit of reference to the issue of domestic violence. When I thought this was the focus here was more on COVID-19 as a claim, as a basis to claim that a child shouldn't be returned. I'm not going to relate to the comments about domestic violence. I do want to say, however, that that the guide to good practice on Article 13.1b, I'm not sure if everyone here has read it, and if not, I strongly encourage you to do so, because this is a document. I think we also have Marie Riendo from Canada. Both of us were part of the working group. This was a guide that took 8 years of work to produce. I don't think there was one word in there that we didn't have discussions about before putting it in. It was very, very carefully considered. And it was approved by all of the member countries at the General Council meeting in March of 2020. So this was a document that was given a great deal of thought to. It was reviewed by all of the countries, all of the member countries, and it was approved. The guide, the reason behind it was because there was such a difference in the way that the exception in Article 13.1b was interpreted and applied by the different countries. There was almost no unity. So it was felt that this document was needed to give the guidance to countries, to judges, to the other players involved in the application of the convention. I'm not going to go into it again. I invite everybody to read it, but basically what it sets out, and there's a very good one-page, almost like a process map to show the process for courts, and I'm not going to go into detail. Basically, the court has to decide if the taking parent established that there would be a grave risk to the child on the return to the requesting country. And even if there is, are there protective measures that can be put into place that would alleviate this grave risk? So there's the exception in Article 13.1b, it's meant for any kind of claim that might arise. New claims can arise, for example, at the time of the guide, obviously we didn't know about COVID, it wasn't a thought at the time. There was raised a number of years ago, there was a suggestion that we should either have some kind of a protocol or we should amend the convention to deal with the issue of domestic violence. But what I want to say is no matter what the claim is, if it's domestic violence, if it's COVID-19, if it's economic concerns, they can all be dealt with by the same test under Article 13.1b. You have to show that if there's a grave risk to the child upon return, and if so, are there protective measures that can be put into place? So it doesn't matter. We need to keep that idea in our heads that we use the same test under Article 13b, no matter what the claim. And that's why I think the courts have been able to do not seem to have had difficulty in applying the exception when the COVID claim was raised. As an example, in one of the Israeli cases that Rona had mentioned, in this case, the children were ordered to be returned, I think it was to New Zealand. Oh no, I think it was the French case actually, or one of them, where the court, they did mention airport travel. They did mention the actual traveling part, and what they said was that the airports were not closed, and if the countries had decided not to close their airports and felt that that air travel was safe, then it would be safe enough to return the children on these flights. The other comment that I wanted to make, and I completely agree with what Paul was saying about the convention, and that we need to remember the purpose of the convention here. And Professor Eichner was mentioning about the children's connection to a particular parent and about the emphasis on the primary parent. And if you look at the Guide to Good Practice, there have been exceptions raised where a primary parent claims they can't go back, or they claim that there will be a separation of siblings. But in most cases, and I've been in the field for quite a long time, I think I've seen close to 2,000 cases. In most cases, there isn't a reason why the parent can't return. They can't just claim that they say that they don't want to return and try to use that as a basis to justify the child not going back, or to claim that there will be a separation from the siblings, unless the parent can show prove a clear reason why they can't go back. For example, if they can't get any kind of, if there's an immigration issue or status in that country, if they cannot enter that country, unless there's something that shows that they cannot go back, not that it's of their own volition, then the taking parent, if they use that claim, then they're basically the one that's creating the risk. We had a case like that in the Supreme Court in Israel, where the parent claimed that the children would be separated, and the Supreme Court said in that case, but you can go back with the child, you can accompany the child, you can take the other sibling back, that's your choice. So again, we have to remember, as Paul said, that the purpose of the convention is to have the child in the place that's the proper place to decide custody. And even if the child is returned and the parent has to go back, they can always apply for relocation after that. And if they're able to convince the court that it's in the child's best interests, the court may allow the relocation. But we can't let all these reasons take away from the real purpose of the convention, or these allegations. We have to look at the real purpose of the convention. And as Paul said, in most cases, the children are ordered to be returned. That's basically what I wanted to say here. Thank you.
Thank you very much. I'll move on to other questions, and then I'll give both Rona and Maxine a chance to comment on all the questions.
Paul, I'm worried about the time.
Yeah, don't worry, I'll manage the time. Thank you, Daphne. Okay. And Ilaria, please.
Yeah, many thanks. I'll be short. I just had a comment. So I think the Peretz Vera report acknowledges the fact that both situations were taken into account, the taking parent as a primary carer and not. However, it's I think in both cases, the issue of violence against women is very relevant, because it can work differently in each of the two scenarios. And I think the studies are still very at the very beginning in this respect. But there is another scenario was not taken into account by the Hague Convention, which is the expat scenario, if I may say, because the issue there was mainly that of immigration. So people trying to habitually changing their habitual place of residence from one place to the other, while now, except for what has been said rightly by Professor Nishitani, that COVID changed a little bit the issue, but now many people are just working for a few years in another country, and the habitual resident there has not a real meaning for the family. So this is a scenario that I think was not really envisaged, and it's also the scenario, maybe it's not a case that changed a little bit the judicial interpretation of the return mechanism with the Abbott versus Abbott. So I would like a comment by Professor Schutz on this, and thank you very much.
Thank you very much indeed. We'll go to Rona straight away, and for just a very brief comment, and then Maxine, brief comment as well, please. Thank you.
Okay. And a number of things have arisen here. Maybe I'll just take the last point, which was mentioned by Ilaria about couples who've just gone abroad for a few years. And that's exactly the point that I discussed in the article, which Maxine referred to, which maybe was lost on people who hadn't read the article, which is called re-relocation disputes. And basically, the point is that I personally, back to Paul's point, I'm sure the drafters of the convention were very clever people and weren't only thinking about one particular stereotype. I agree with that. How much they actually thought about what we call today people going abroad for a few years and back, I'm not sure, because they didn't really think that much about the problems of habitual residence. The drafters don't seem to have thought that habitual residence might be a real problem. I mean, if you look at the cases, you see about half the cases, the question is where the child is habitually resident, in cases where he has a contact with both parents. And it's almost like tossing a coin. And that is a problem. And I agree that is a problem. The question is how to resolve it. I don't have an immediate answer, but on the other hand, obviously habitual residence does have to have some physical context to it. It can't be only intentions. So I'm not sure I can answer that in 2 minutes. I can refer Ilaria to my article. If you want to send me an email, I'll even send you a copy of the article. In relation to the other points made, of course, I certainly shouldn't be taken as suggesting that the convention is something that we shouldn't be continuing with. And as Paul said, in most cases, it probably works very well. Although I suspect we don't even know about most of the cases, certainly not in Israel, because they're not reported. Cases, or they don't even get to court, I suspect. Cases which are simple and it's obvious that the child has to be returned, then presumably that happens pretty quickly without often any court case. On the other hand, there are a significant number of cases in which there are real issues about whether actually returning the child will cause him harm. COVID is one of those cases, maybe not that difficult in the sense as we've seen, it's often just a question of time, although of course, as I said before, it depends exactly how we define risk. But the other sort of case, and the reasons I talked about it was the domestic violence case, because this is a much more common situation, it has been and is going to carry on being the case. I thought we could actually learn from the analysis of COVID, of seeing how difficult it is to define grave risk in the COVID context, to learn from that, but also in the domestic violence context, how do we actually say what's a grave risk? What one judge will think is a grave risk, another judge won't think is a grave risk. It can't be proved so simply. And that we do definitely need to give more thought to. And the good practice guide has got some good points to it, but I don't think that it actually comes sufficiently to the right balance in relation to into domestic violence. That's my view, and I've written about that elsewhere.
Can I stop you there, Rona, just for time? Sorry.
Yes.
Sorry to interrupt. Maxine, just to give you a minute or two so that we can then move on. Sorry.
I know we are short on time. What Rona said, excuse me, about the focus of the Hague Convention on habitual residence is essentially what I'd plan to say.
Yeah, all right, that's a consensus point. I want to be clear. I also agree that the drafters underestimated the difficulty of deciding habitual residence because the Hague Conference underestimates the difficulty of deciding habitual residence, and they took it for granted it would be an easy connecting factor. It isn't. We're all agreed on that. It does cause problems, and that is something that still needs work on. I'd like to see personally more emphasis where parents can agree on the habitual residence, that should be given effect to. But I agree where parents are at loggerheads or are at disagreement, then we're in difficult territory and it's not easy to come up with the answers. Thank you very much.
Yes, can I just say one small point for those that haven't read the article? Obviously, most people haven't. One of the points I make in the article is that parents should be encouraged to write agreements before they go on these relocation, and some effect should be given to those agreements, at least where the agreements clearly were made voluntarily without duress. So I think we're agreed on that point.
Great, thanks, Rona. We are agreed on that. Thank you very much, and we'll move on immediately to our second speaker, Nofar Yakovi Ganor, who is a JSD candidate at Columbia University Law School. She did a political science and law degrees at Tel Aviv University before going to Columbia, and she has published in this field in the Journal of Law and Biosciences an article on Going Solo, the law and ethics of childbirth during the COVID-19 pandemic. And her title for this talk is Birth Interrupted, Cross-Border Childbirth and the COVID-19 Pandemic. Over to you, Nofar.
Thank you, Paul. I'm just sharing my presentation. Okay. Okay, so thank you very much for the opportunity to present my work here today. And thank you to Daphna and the academic committee for putting together such a wonderful and timely workshop. The topic of my paper is cross-border childbirth, and I wanted to begin by giving some context on how I came to write this paper and focus on childbirth during the COVID-19 pandemic in the first place. So around March of 2020, I was living in New York City, which at the time was quickly becoming the epicenter of the American coronavirus outbreak. The New York State Department of Health started issuing these emergency advisories for hospitals and care providers. One of them concerned hospital visitation policies. In response, several hospital networks imposed visitation bans, including on partners and support persons of birthing women. Now, these policies drew a lot of attention, including mine, which motivated me to learn more about how the pandemic is affecting the reproductive landscape in the United States, and specifically childbirth. And among the many things I've learned was that the concern over how pandemic-related policies will affect birthing experiences led some people who have the means to do so to either travel to another state to give birth in a hospital with more lax policies, or even temporarily relocate for the duration of their pregnancy. And at first, this may seem as a relatively insignificant consequence of COVID-19. However, by conceptualizing it as yet another case of cross-border childbirth, it presents an opportunity to explore a relatively under-researched aspect of the cross-border reproduction movement compared to such practices as surrogacy and abortion. The second objective of this paper is to challenge prevailing characterizations of what is controversially referred to as birth tourism that fail to recognize the magnitude and complexity of this phenomenon. Birth tourism is commonly associated with the growing transnational family arrangement where expectant mothers travel to a country with a birthing citizenship system so that their children will be born citizens of that country. However, I argued that juxtaposing different examples of cross-border childbirth reveals that families have other reasons for pursuing childbirth across national and international borders, including restrictive reproductive policies in their place of residency, the inability to access safe and adequate labor and delivery care, as well as the absence of delivery-related services such as non-medical birth settings and midwifery. In doing so, it shows cross-border childbirth to be women's rights. So the way I've organized my analysis was by identifying 3 travel patterns among expectant mothers and their families: international travel into the United States, interstate travel, and international travel out of the US. Within each pattern, I discussed several examples of cross-border childbirth that are differentiated by the motivation behind the decision to pursue childbirth services in a different country or state. The first and most known pattern involves movement into the United States. As I suggested earlier, the most known reason under this category is birthright citizenship laws. The US is one of the few countries with such system enshrined within the citizenship clause of the 14th Amendment. This feature has made it into a popular destination for expectant parents who wish to provide their children access to the advantages associated with US citizenship, such as healthcare, education, and employment. It is common, especially among families from Central and South America, China, Korea, Turkey, and Eastern Europe. Now, this practice is problematized, particularly from the perspective of birthing women and their families by several factors. To begin, while birth tourism programs are mostly safe, in others, an attempt to save costs may result in higher death rates and complications for birthing women and their children. Operating in several states, including New Jersey, New York, and California, these programs offer families services costing between $5,000 to $45,000. This amount covers medical services, travel expenses, visas, and room and board, at times in violation of zoning laws and while committing insurance frauds. Second, most expected mothers travel to the destination country by themselves, leaving their family members in the country of origin, including spouses, children, and elderly parents. They spend between 3 to 7 months away and eventually give birth alone. In one study describing the experiences of Taiwanese women who have participated in birth tourism to the United States, women described feeling helpless and lonely, and at the same time, a lack of autonomy when their husbands and other remote family members tried to control their daily routines through phone and video calls. Some of them even reported that the decision to give birth abroad was not even theirs, but their husbands. Further complicating this experience is the fact that this practice receives significant political, carries a lot of stigma. Calls to limit the birth tourism industry are often infused with racializing and stereotypical language, portraying members of Asian and Latin communities as threats to the United States. These calls seem to ignore the fact that this practice, at least up until 2020, has been completely legal. However, one fundamental problem in the debate surrounding birth tourism that I focus on is that the debate focuses on pull factors that lead families to engage in cross-border childbirth and disregards the push factors. Examples include the absence of accessible and safe delivery service in the country of origin, mandatory military service rules, disparities in education, and economic concern. Another example for a push factor that I would like to elaborate on is restrictive reproductive policies, such as those prevailing in China, which for many years drove families to give birth abroad in order to circumvent its one-child policy. Yet even today, childbirth among unmarried women remains illegal and penalized by a social maintenance fee in China. Also, all social welfare, such as medical care and education, is regulated by a system of household registration that limits illegitimate children's access unless a marriage certificate and other documents required for registration can be obtained. Unmarried women also have limited access to reproductive health information and services that are considered relevant only to married women. Some of these limitations also apply to same-sex couples. Giving birth abroad allows these families that break from the heterosexual model to avoid at least some of the penalties associated with violating China's population control policies. In that sense, it is a way to exercise reproductive autonomy and their right to family rather than to attain socioeconomic advantages for the future children. The second type of travel pattern I discussed in the paper is interstate travel. This category involves cases where expectant mothers cross state borders to receive maternity care and give birth in another state. Here I focus on two examples. The first I mentioned at the beginning of my presentation examines the interstate movement generated by COVID-19 hospital visitation policies implemented in several hospitals across the country, including in New York, California, and Pennsylvania, which banned or otherwise restricted visitors from obstetric departments. Another example I used in my analysis that I want to say more about now involves expectant mothers living in prohibition states where midwives are not allowed to practice. The United States is one of the few countries where, unlike most developed countries, midwives are not the primary healthcare providers for maternity care. Childbirth practices, such as using a midwife as a birth attendant or home birth, are often viewed as archaic, although this has not always been the case. Several developments taking place in the 1960s and on have led to the reemergence of midwifery in the US. Among these are the growing dissatisfaction with the medicalization of childbirth and a consumer-led push for natural birth options and alternative birth settings and experiences. These developments require states to legislate or otherwise regulate the profession in order to determine its legal status. And while most states opted for legalizing the practice of midwifery, 9 states and the District of Columbia prohibit direct entry midwifery, a term used to describe midwives that enter directly into education and practice of midwifery rather than through nursing education. Against this background, reports from recent years suggest that a growing number of pregnant individuals living in those prohibition states decide to cross the state borders in order to avoid these restrictions. Some opt for a midwife because of deeply held religious beliefs. Others are motivated by a traumatic hospital experience in previous birth. In Alabama, for example, where direct entry midwives are not permitted to practice, expectant mothers travel to Tennessee, Mississippi, Georgia, or Florida in order to give birth. Some women would drive as much as 2.5 hours or 5 hours to see their midwives for every prenatal appointment throughout their pregnancy. In one example, a mother described how she would wake up at 5 a.m. to be able to leave on time for her appointment, take her 3-year-old along with her, and still be back on time to pick up her older 2 boys from school by 2 p.m. In some other instances, women would make the drive while already in labor, hoping not to have the baby in a parking lot or by the side of the road. Even if they arrived to their destination on time, they would give birth in secret and improvised settings such as Airbnbs, cheap hotel rooms, campers, or at a network of anonymous birthing cottages. In both examples, cross-border childbirth provides women a greater measure of control over how they bring the child into the world, yet it also poses significant risks to the emotional and physical well-being of the birthing woman, her future child, and her other family members who are often not part of the birthing experience. The third travel pattern within the cross-border childbirth movement I wish to just point out to is international travel out of the US. Although cross-border childbirth is predominantly associated with movement in the opposite direction, I hypothesize that there are families who are seeking to leave the US when faced with the prospect of having children, described by one article as reverse birth tourists. The high costs associated with both having and raising children in the United States and its high neonatal and maternal mortality rates compared to other developed countries are just 2 examples for push factors that may lead US residents who have the means to do so to search for alternative birth territories. However, there is almost no research on American residents who travel abroad in order to have a baby, and very little information about Americans who live overseas in general, common destinations, occupations, and motives for leaving the country and ultimately staying abroad. Nevertheless, I think realizing the capacity in which this type of cross-border movement exists can undermine some of the assumptions underlying the United States migration debate. One of them being that, and I quote from the book Americans Abroad, "While people abroad want to immigrate to America, Americans themselves do not wish to emigrate." It can also provide further evidence for the difficulties faced by families, and particularly mothers in the pre and specifically post-pandemic reality that can be remedied by better health coverage, paid family leave, and subsidized childcare. So the second part of my paper, I consider how the cross-border childbirth movement has been affected by COVID-19 regulations and policies, particularly how it may exacerbated difficulties already inherent in this experience. To begin, one essential feature of cross-border childbirth that allows this practice to exist is pregnant non-nationals' ability to cross international borders with relative ease. 2 developments taking place in January 2020 have made it substantially harder. First, in January 22nd, a new rule was imposed by the Trump administration in order to block pregnant women from visiting the country. The new rule requires pregnant women to prove to the consular officer either that they are not traveling to the US to give birth or that they have a legitimate medical reason to give birth in the country. The ethics and efficacy of the rule have both been called into question, among other reasons because it makes immigration officers who have no medical training responsible for adjudicating people's pregnancy. At the same time, it could have a detrimental impact on pregnant women who require medical treatment by delaying their entrance into the United States to receive care. The new rule also operates to perpetuate the negative and often racist view of cross-border childbirth as an abuse of the American immigration system. Later that month, in January 31st, the US suspended the entry of non-citizens of both immigrants and non-immigrants from China, among other destinations, into the country. These types of international travel bans imposed by many countries across the globe with the break of the pandemic as an attempt to stop the spread of the coronavirus provide the most obvious example for how COVID-19 restrictions disrupt movement both into the United States and out of it. And while some exceptions were made, for example, for lawful permanent residents or aliens who are spouses of US citizens, they provided no recourse for pregnant individuals who enter the United States on either tourist or business visas. Over a year later, these restrictions were still in place. There is still no available data to determine the actual effect of these travel bans on international childbirth travel, but it is nevertheless helpful to look at how similar COVID-19 travel bans affected this practice at another attractive destination, also offering birthright citizenship, which is Canada. One province in Canada saw a spike of almost 22% in non-resident birth in the year that preceded the outbreak of the pandemic. A hospital in that same province reported a drop of about 75% in non-resident birth in the first 5 months of the pandemic. Like other countries, Canada banned the entry of foreign nationals into its territory, regardless of their origins, except for certain groups of exempt individuals. It is likely that the international travel ban, paired with the new immigration rules imposed even before, had a similar effect on childbirth travel into the United States. In the context of interstate travel, at the same time that COVID-19 policies gave rise to new travel trends by creating new motivations for seeking childbirth services in another state, as in the case of hospital visitation bans, they also made this type of travel much harder. Each state across the United States has adopted its own regulatory response to the pandemic. Restrictions on entering and exiting the state, mandatory quarantine periods, and shutting down of non-essential services all became common features of such policies, making these borders more real and visible than ever. For those wishing to access a childbirth-related service at a neighboring state, assuming this option remained available, they now had to arrange for a 2-week stay away from family, including time away from work, accommodation, and for many expectant mothers, childcare. These restrictions made traveling a much costlier endeavor in terms of the financial, but also physical and emotional burdens it entails at a time when people were already losing jobs along with their health coverage. Paradoxically, as the Center of Reproductive Rights explains in its report on how the COVID-19 pandemic is exacerbating a human rights crisis in maternal health, it was during the pandemic that the legal and cultural marginalization of midwifery and community-based birth settings and the, quote, overwhelming reliance on hospitals to manage pregnancy and birth have become a problem since the latter were overwhelmed with sick coronavirus patients. As a result, expectant mothers' inability to access reproductive care and control where to receive such care, give birth, and who to birth with has been significantly constrained. The third and last part in this paper, that in the interest of time, I will not say much about, points to national policy areas where changes should be made to first, better protect people's rights to family, health, and reproductive autonomy, making them less susceptible to the effects of national policies adopted in times of crises. Second, respond to the needs of families that give rise to different strands within the cross-border movement. For example, this essay offers to reconsider the place that women's right to control where and how they give birth holds within American law. For example, it questions why the right to reproductive autonomy that has been recognized as a constitutional right in a series of cases during the 1960s and the 1970s has been traditionally understood to protect the decision whether and when to give birth, but not where and how. As I explained elsewhere, part of the anger and confusion that many people experienced after learning about childbirth visitation bans may have come from realizing that to date, there are no US laws that would prevent a hospital from forcing women to birth alone. It also suggests re-examining immigration policies that target non-resident pregnant women, specifically the decision-making process that preceded their implementation, the data supporting the need for such policies, and the underlying assumptions about US immigration. The new rule mentioned earlier, targeting pregnant women, is a prime example of such policy. To conclude my presentation, my analysis shows that people have various motivations to engage in cross-border childbirth. This practice provides individuals an alternative route to start a family, access to childbirth and delivery services that would otherwise not be available, and control over their reproductive experiences. By understanding the motivations that lead people to pursue this practice and the difficulties they must overcome while doing so, including being separated from one's family, birthing in a foreign country, and sacrificing certain aspects of their birthing experiences in favor of others, we can begin addressing the challenges that traveling across national and international borders holds for birthing women and their families. Furthermore, while my paper focused on cases where pregnancy and childbirth are the principal reason for people to cross borders, there are other cases where they are incidental to this decision, as in the case of some refugees and asylum seekers. A Times article from earlier this year describes the experience of pregnant asylum seekers from Mexico who arrive at the US border after fleeing gang violence and immediately being sent back, sometimes while already in labor. The implementation of migration protection protocols during the Trump era, also known as Remain in Mexico, along with the temporary shutdown of immigration courts with the spread of the coronavirus, has made these cases more common. I hope my project and other projects dedicated to cross-border childbirth will create scholarly space to account for these stories and voices as well. Thank you so much for listening.
Thank you very much indeed, Nofar, for that very clear presentation and very timely presentation. Thank you so much. I'm going to introduce the commentator on your presentation, and then there may be just a little time left for comment if we run over just a little bit on our allotted time. Professor Zvi Trigger, who's Professor of Law, the Chaim Strix Faculty of Law, the College of Management in Israel. He has extensive publications on sex, gender, and family law issues. He has an LLB from Tel Aviv University and an LLM and JSD from New York University School of Law. Zvi.
Thank you very much, Paul. And thank you, Nofar, for this fascinating presentation. I'll try to be brief in my comments because of the time constraint. And I'll start by saying that your typology of cross-border childbirth is very interesting and helpful. I learned a lot from it, and I'm immersed in this area of research. I have been immersed in it for quite a while, and I'm also not just a scholar of a cross-border childbirth, but also I practiced it, if I can say so. My youngest daughter was born in April 2020 in the US. So we experienced it firsthand, and I found the notion that not all cross-border childbirth is a middle and upper middle class phenomenon very illuminating. The idea of intentional cross-border childbirth brings to mind, I think, Michel Foucault's argument about power, about the fact that whenever there's an exercise of power, there's creativity. Foucault writes in Power and Knowledge, and I quote, "Power must be analyzed as something which circulates or as something which only functions in the form of a chain. Power is employed and exercised through a net-like organization. Individuals are the vehicles of power, not its points of application." And cross-border families in general, but also the cross-border childbirth is a very good example of the human creativity at the backdrop of the exercise of power. The idea that if a woman cannot give birth with her significant other, for example, beside her because of the pandemic, and therefore she chooses to travel to a different state where such a restriction does not exist, is one example for the idea that individuals are the vehicles of power. Another example that you mentioned, Nofar, in your presentation is that of a woman that cannot give birth in her homeland because she will be in trouble with the authorities if she does so, and then therefore she travels abroad to give birth outside of her country. An interesting cross between cross-border childbirth and international surrogacy is the phenomenon of surrogates from one country who are taken to give birth in another country. This happened, for example, in India when surrogacy for international intended parents was banned after 2013, and Indian surrogates were taken to Nepal to give birth there. These are all manifestations of the human creativity that legal, political, economic, social, and other restrictions encourage. In this context, cross-border families in general are the product of human creativity, as I mentioned, against the background of all kinds of limitations. But the pandemic is not a force in the sense that Foucault talks about. It's not a state force, it's not an organizational force. And as mentioned in previous presentations, it might have provided new opportunities for some countries, as you also mentioned, Nofar, to exercise more power over those in cross-border families, and in turn were met with more human creativity, such as the Love is Not Tourism movement, and other forms of creativity that we learned about in the past year or so. In the specific context of cross-border childbirth, I would like them to first ask about the bundling together of the various instances of cross-border birth that you do in the paper. The three categories that you discuss are very different from one another in terms of the reasons for travel, the necessity of travel, the consequences of the travel ban on the women, on the pregnant women, and other considerations. Is it helpful in thinking about possible policy solutions in times of crisis, such as the COVID-19 pandemic and the travel bans that were put in place as a result, if we bundle together women who wish to give birth with a midwife in a state that does not allow midwifery, with women who have to give birth abroad, otherwise they will face legal consequences at home because they're giving birth out of wedlock. In other words, should we distinguish in terms of both analysis and possible solutions between the three groups, and dedicate a separate research, separate paper for each one of them, if we want to think of effective policies and solutions for these very distinct three groups. I'm thinking, for example, of women who travel in order to give birth in another country, or if American in a different state for reasons such as legal restrictions, as I mentioned, in their home country or state, as opposed to women who travel in order to have their newborn obtain an additional citizenship, not out of not as a matter of life and death, but as an opportunity in life, a new opportunity in life. Is it possible and practical to make distinctions on the policy level between these categories in times of emergency, such as a global pandemic? And do we want to do that? Is there a moral justification for such a distinction? Perhaps, and that's like a very tentative offer, we should distinguish between what you mentioned as a controversial term, and I think justly so. We should distinguish between childbirth tourism and maybe, I just offer it tentatively, as I said, childbirth refugees. Perhaps we should introduce the child's best interest principle into the net of considerations that could shape the relevant policies. And given that that countries should be able to balance health considerations of their own citizens and residents in times of a pandemic with the reproductive rights of women. I think that dividing the categories, breaking them down to tourism as opposed to childbirth refugees, maybe it's not a very successful term, but we can think about it. It could help in coming up with proper policy solutions. Thank you very much.
Thank you very much indeed, Professor Trigger. I haven't seen any hands up, so I don't think anyone is desperate to make an intervention. So I think if no far, I'll give you a minute or two just to respond, to pick up anything that you want to from Professor Trigger, and then we'll hand over to Ruth, who's chairing the next session on transnational homes.
Thank you, Paul. I'll be brief in order not to bite from the time of the next panel. Tzvi, thank you so much. This is really brilliant and insightful. So I agree that bunching all these examples together is in several ways problematic, especially when you think about the solutions that you want kind of tailored to each kind of example or each kind of case, considering the motivation behind cross-border travel. The reason that I thought about kind of doing some sort of an overview and kind of giving a sense of how varied are the motivations for that is because there is so little research about this particular aspect. And I think that one way to show something as a phenomenon rather than not like as an isolated case that doesn't really deserve any attention is by kind of showing how it operates in different directions and has different motivations for why people do that, and then to show it as part of something that kind of prospers and we find new and more motivations for women that are more basic than just kind of getting the advantage of a US citizenship for why they do that. So that was kind of my motivation of trying to provide some sort of a comprehensive account of this phenomenon. But I agree that in terms of tailoring solutions, your conceptualizations of birth tourism versus refugee, childbirth refugees, it could work better to kind of in thinking about that. So thank you very much for your comments and for everyone for listening.
Thank you very much indeed. Thank you to both speakers, both commentators, and everyone who participated. Over to you, Ruth.
Thank you. It was wonderful. So good evening, everyone. Thank you all for both organizers and the participants for this fascinating, timely, and very original workshop. It's really great to be here. In our session, Ms. Anjali Marilla will present her paper, Immobile People, Immobile Things, Mixed Couples, Family, and Home Experience with Restriction Rules and Circulations of Objects during the pandemic. I prefer not to interrupt the flow of our session, so I would present both our speaker, Anjali Marilla, and commentator, Keynote Lahad, in advance. So our speaker, Ms. Anjali Marilla, is a PhD candidate at the Université Libre de Bruxelles in Brussels, Belgium. She's currently working on her doctoral thesis on materiality, mobility, and conjugal, it's too late for me, I guess, mixedness and at the Laboratory of Anthropology of a Contemporary World. Her research interest and work traverse along lines of visual anthropology, cultural sociology, history, material culture, migration, and Southeast Asian studies. Her doctoral research project is initially funded by the ULB ARC project on Belgian Asian couples and is currently funded by the Belgian National Fund for Scientific Research. Our commentator, Dr. Keynote Lahad, is a senior lecturer at the Women and Gender Studies program at Tel Aviv University. She had been involved in various prestigious research projects which merited international attention, Prize and materialized in publication in leading journals. Her book, A Table of For One, a critical reading of singlehood, gender and time, was published by Manchester University Press in 2017. Her current project includes studies on friendship, aunthood, temporality, intimacy, and effects. I'm looking forward both to the paper and comment. Anjali, the screen is yours for at least 20 minutes.
Yes, thank you, Ruth, for your introduction. If you will just let me share my screen. I think I am disabled too. So
Einat will do so, yes.
Yes, you can do it now.
Okay, great. Can you see it and can you hear me well?
Yes.
Okay, so first of all, thank you for the organization of this online workshop. I'm very delighted to be here as a young researcher and present some of my research data that is drawn from an ongoing fieldwork for my PhD research that I started in 2019. So this is somehow another perspective, once again, of how the pandemic, on the one hand, generated new insights into understanding an important facet of the migrants' family life when they are restricted with rules of, let's say, forced immobility, and how, on the other hand, the current situation also influenced how the researchers rethink research questions and methods of research. All right. So for this presentation, let me first clarify that my titling is in fact about mixed couples and their home experiences. I will somehow extend the earlier discussion on mixed couples by looking at their experiences during the lockdown while they were confined in their homes. I will attempt to give an overview of the more micro experiences of mixed couples, as you can see here in the photo behind closed doors during the lockdown. Within their domestic space. Here I am using a rather different lens. It is more anthropological and about material culture. And in this perspective and for this workshop specifically, the discussion will be about how the pandemic changed domestic practices and how restriction rules affect certain family cultural traditions, and how consequently the immobility of people meant immobility of things. Okay. So my work is generally about home objects in the houses of Belgian Vietnamese couples, both in Belgium and in Vietnam. What kinds of objects are these exactly? Home objects here pertain to everyday things in the household of mixed couples. It could be decorative, static, functional, religious, or secular. So these are basically usual things found in everyday settings. It could be a bowl, a set of plates. It could be a statue of a Buddha, a teapot, a microwave, or sofa, or any home decor. In my research specifically, I incorporate the concept of transnational home, which means that home, especially for migrants, is rather mobile, portable, dynamic, and mutable, which is called homing in the literature, acknowledging the sociological work, for example, of Paolo Boccagni to emphasize homemaking as a process. So in simplest terms, I situate these home objects in the perspective of mobility by emphasizing on the trajectory of these home objects. Oops. Right, okay, so my research is guided by what we can call material methods. So it's a little bit far from what we were talking about international law, but I will speak about some restriction rules also that impact the way of life and family life of these couples. So I use object interviews just to give you a general overview. It is related to the more established method of photo elicitation in anthropology. In its basic sense, an object interview is an interview that incorporates by the object. The couples are asked questions about the overall biography of the object to draw out their narratives and experiences. Let me use this painting as an example. So this is a reproduction of a famous painting called Young Woman with Lily. It is originally painted by a French schooled artist in 1943. The couple who owns it recalls that it was a wedding gift. It traveled from northern province to Saigon and journeyed to Belgium and lived in different rental apartments. Then it moved to their newly bought house following the success of their restaurant. It was formerly displayed in the living room. Now it hangs in the restaurant, making the object available in somehow, I say, my public space. The couple recalled the trajectory of the thing, its life history, and narrated their marriage story as well, and their social mobility in Belgium. However, the restaurant is now on the brink of bankruptcy because of COVID, since the government closed all the restaurant and considered them as non-essential. Their restaurant, for example, only operates for takeaway for dinner, and even closed during the warmer months because they didn't have the terrace or the outdoor sitting. Okay, so the object interview and trajectory is methodologically related to multi-sited ethnography, which is called follow the thing method. It centers on the movement of things through space and time as objects are moved into different contexts. For example, this is a storybook that a grandfather asked me to bring from Hanoi to Brussels. I went with him in the bookstore where he looked for these books that he wanted to give as gift to his granddaughter. I gave it to the family when I arrived in Belgium. It was lovingly received by the family, and now it sits in a corner of the living room of their apartment. So follow the thing method, in fact, allowed me to participate in the mobility of the object, how the object was sent, how it traveled, and how it was received. Second, I witnessed the shift in a commodity situation, borrowing the concept of a padirai. For example, the price of the booklet is about 30,000 dong, or just over €1. It became a prized possession once it arrived in Belgium. The kid brought the books to share with her classmates. In the Vietnamese language school, she was proud that her ông Noi, her grandpa, sent her a gift. So this speaks of how circulation of objects play a big role in maintaining kinship, and also gives a gist of how, in fact, I originally approached material methods in my pre-pandemic fieldwork. Okay. So methodologically speaking, I think this is the problem of all of us currently, that during the lockdown, as it is restricted to travel, I am forced to bring these material methods in my online interactions with my informants without losing the visual component of the methodology. So I made my informants as active participants of photography and image making. I let them choose and take photos of their stuff at home, and you will see that in the next slides. Likewise, these couples, who are mostly, in fact, mobile, especially for the Vietnamese migrants who periodically do return visits where they bring along gifts to Vietnam or visit family members in other countries, are restricted to travel, as of course the rules in Belgium only defines essential travels to outside of EU as limited to diplomatic, medical, and professional travels, or later on immediate family reunification. And visiting relatives was considered non-essential travel. So in fact, the restriction rules during the lockdown created this binary of what is essential and non-essential, and many cultural activities, including that of the migrant transnational life, is absorbed in, let's say, sadly, the non-essential rubric of the government. So how did the travel restriction consequently affected the circulation of things? Well, for most of my informants, they would usually speak of transnational gifts as genuinely delivered in person, meaning hand-carried by themselves, by a relative, or by a friend. As you can see here, many are skeptical about using professional courier or postal services. They said that it's difficult to trust with the current situation, not certain when the parcel will arrive, or they are worried about things arriving as broken. They say it's expensive than shipping fee, and it could possibly cost more than the parcel. So usually you will see these families carrying big boxes and many luggages every time they travel to Vietnam or back to Belgium, because one, they bring a lot they bring a lot of stuff for and from their families, and two, on the top of their belongings and gifts, they also bring those things of their friends to and from their stay-behind families. Let's say reciprocity is pretty common. Something like, I bring your stuff now, you will bring mine later. So while they facilitate the flow of things across borders as they travel, they also create trust or build social capital within that migrant network to whom they consider as their kinship network in Belgium. So kinship is something that is also built along while they facilitate this circulation of objects. Objects travel all the more during the Tet. Tet is the Vietnamese Lunar New Year. It is a very important tradition in Vietnam where people come together, where they clean their house to purify the home from bad luck, or bring lucky colors and decorate their homes for the Viet Kieu. Viet Kieu is the term used to refer to the Vietnamese living overseas, and the Tet is considered as homecoming. So it's very important for them to in fact go home to Vietnam once a year. And it's the best time to go and to do big shopping and bring back stuff like Vietnamese kitchen utensils, ceramic bowls, or as simple as wooden chopsticks and decorations of different form and sizes, or things like that. And this is true especially among second-generation children of migrants and mixed couples with children. Most of my informants in Brussels emphasize the importance of sending their children to Vietnamese organizations and to own at least one cultural item like an áo đai that comes from Vietnam. And áo đai is the Vietnamese traditional clothing. In my fieldwork in the school in Brussels, I noticed that the children of mixed couples know more their Vietnamese language and culture than their peers whose parents are both Vietnamese. While I observe that learning the language and return visits has been well emphasized in the existing literature as a strategy of ethnic authentication for these Viet Kieu, like the work of Tamsi and Barber in the UK, less has been mentioned on the role of cultural things that are usually displayed at home in reinforcing kinship ties and ethnic identities. For example, Sarah told me that her Vietnamese father and Belgian mother, Bao and Maite, bring back decor with them yearly every time they go to Saigon for the Tet until their house started to look like a restaurant. In fact, return visits and bringing in decor was Bao's way to reclaim his Vietnamese ethnicity and reputation in the village. This is because those Viet Kieu who stay in contact with their left-behind family, meaning those who fulfill their obligation of kinship through 1, return visits, 2, sending remittances, 3, by sending gifts, are considered Chin Kong, or the real Viet Kieu, and entitled to retain their Vietnamese identity even if they live abroad and married a non-Vietnamese. And owning cultural objects at home is part of that reputation and obligation. The experience of mixed couples is rather complex because I want to argue that they negotiate an experience home in more than just one space, but in multiple transnational homes. Aside from their current residence with their partner or family of procreation, home also means the house where they grew up, usually the place of stay behind family, parents, and relatives. Also, all of my Vietnamese informants would consider themselves middle class, and they have relatives living overseas who are part of the diasporic communities in France, Australia, or in the United States. And object circulation exists within these social spaces as well. For these couples, in fact, they had more than one marriage ceremony done or wedding ceremony done in different places. I have to mention also that when I shifted to online ethnography, they seem much more open and comfortable when I engage with them online. This is essentially because the web camera is part of their daily life. It was not a new normal for them at all. It has been a usual everyday routine of transnational communication where they reconnect with family. They also project their aspirational homes. Some of these couples are building or they plan to build remittance houses for future plans of retiring in Vietnam. They also speak about past homes as other houses that they own or the past places where they lived, especially among Belgians who were previously divorced and now living in Vietnam with their new partner. They have also left behind children in Belgium. One example is Julian. He is a Belgian who is living in Ho Chi Minh City with Thuy and had 2 kids with his ex-wife in Belgium. He told me that it's not because there is a pandemic, like what our speakers mentioned, that the pandemic in fact highlighted all the more the social issues that are already there. And he said that it's difficult to move stuff and that there are already more strict restrictions prior to the pandemic. He said that he was not able to bring his books and CDs, vinyls, because of restrictions and censorship in Vietnam that has long been established by the socialist regime. So in fact, the objects that move and cross borders are also entangled with the objects that remain immovable and stay behind. That regimes of mobility is not limited to the question of who cross borders, but also what is permitted to cross borders or what are permitted to move. And also seen in a micro level perspective, mobility of objects impacts the migrants' emotions and ways of feeling at home, making the mobility of objects across border, let's say, as equally important as mobility of people. For example, in migration studies, we say that there is this chain of care, that when a migrant mother moves, the stay behind children are entrusted for care to a close relative like an aunt or a grandmother. And this chain of care is also applicable to objects like a child. Julian's left behind vinyl collection is also entrusted for care. Okay, so now the question is, where is the winness among these mixed couples? Well, it's basically related to the overall idea of homing, that home is a process and as experience. It's related also to what Professor Collet talked about, couple as an ongoing process. And so negotiation and compromise among couples change throughout the life course of the couple, that at the beginning of the relationship, it's pretty much different to the experience when they have children. For example, for these couples at the beginning, it's the person decorating the house. If I'm the Vietnamese, the house. And then if you're the Belgian in Vietnam, you will do it because you are the person in mobility and you want to live your life in Belgium through the contents of your home. And this will change as they have children. And in fact, these children would go to different organizations. They have a Belgian football team and they have the how do you call this, Vietnamese cultural organization in Belgium. Okay, so the pandemic brought new experiences into their family life, like what Ken shared here when she talked about her sewing machine. At the beginning of the lockdown, face masks were not accessible at all. The masks were solely used by hospital frontliners. The bulk of those masks came from China and Vietnam, in fact, and the masks are available that are available to the public are usually handmade, do-it-yourself, made from recycled fabric. Even those masks that the commune or the municipality of each town or village provided the public, and that were only distributed much later in June 2020 after 3 months of lockdown. So families were creative in making their own, like what Ken shared here. During the pandemic, of course, family needs changed as well. At the beginning, it was also very strict, and only one per household is allowed to do the shopping. For example, Maximilian was complaining that it was him who was doing all the shopping because his wife cannot drive, but wanted a lot of stuff. He would always tell me, she is so Vietnamese, she is so Asian, she doesn't want to drive. And then later on, as they stay more and more at home, they needed more stuff to improve their house. And this is in fact true among all of us. So when IKEA finally opened, the rule was still one shopper per household. So the couple was secretly shopping and pretended they didn't know each other because they wanted to buy a bed. And buying and choosing a bed frame and mattress is also a conjugal decision that they have to make. And in fact, they were kicked out of IKEA because later on someone saw that they are in fact together. And it was in fact part of one of the headlines in the TV in Belgium.
Angelique, okay, we have like 1 or 2 minutes, if it's okay with you.
You will just let me to finish 2 slides and sure, that's it.
Sure.
Thanks. Okay, so they needed all the more to buy furniture, that they needed to create new spaces inside the house, like home office and study corner for kids. Like Chow, a Vietnamese woman living in Belgium, said that he was constantly rearranging stuff to ascribe newness to their living spaces, or finally have the chance to organize and tidy up and create new spaces for work and for the kids area. And she needed to buy an office table, chairs, and shelving. Or his husband wanted to work more in the garden and buy gardening stuff and greenhouse to start a vegetable garden. But even if these couples talk about these new spaces in the home and creating boundaries within the home, they would also complain about the house as having no boundaries anymore. Decluttering, of course, has been one of the many chores and activities during the pandemic. Anne, a Vietnamese in her 40s who come from rural, more time and not wait for spring cleaning. She usually collects her old or unwanted or unused stuff to send to her province almost every year. Those who come from more rural Vietnam and experience a dramatic change or difference in the living condition and lifestyle would not normally throw their stuff or put in the streets for donation, like what is normally done by many households. Her own story of mobility through marriage migration shaped her strong attachment to the principle of gratitude and philanthropic work. She thinks that this practice is the more virtuous way to let go and give new life to objects by sending them to her place of origin. Okay, so these are just a few empirical examples in an anthropological perspective of how couples, especially the migrants' home experience during the lockdown was, shaped, and how home objects can narrate those experiences. That houses is not just a living space, but a container of kinship. That home objects reflect changes in their life course, their family experiences, and how things at home materially exhibit these ways of negotiating and maintaining connections across their transnational homes, let's say beyond the binary of the here and there. I will stop there. Thank you for your attention.
Thank you. It was beautiful. Kinneret, your screen.
Okay. I don't need any PowerPoint. It's just me. Okay. Thank you. Thank you, Ruth, and thank you, Anjali. Well, this is a fascinating paper which made me think more about objects, digital technologies, everyday interactivities, disconnectivities, continuities, and ruptures, which cross-border families experience during COVID and lockdown. I will begin my comments by linking this paper to one of the most important research traditions in family sociology over the last 2 decades, which is to examine family life as something that people do and practice, thus perceiving family as a verb and not as a static noun, an approach developed by David Morgan from the UK and Margaret Nelson from the US. Extending this line of analysis, Janet Finch suggests that as sociologists, we should look at how families are displayed and to whom they are displayed. Responding to this paper, I suggest that these significant contributions to the sociology of family life can add much, I think, to the theoretical framework of your paper in highlighting the ways in which familial togetherness and separateness and Vietnamese identity, as you so beautifully have shown us just now, are done and displayed through home objects and via digital technologies. So I'll begin with my first observation in the paper, which I found quite illuminating when you discuss the experience of conducting an online ethnography, and in this case, object interviews. You report that the participants in your study felt very comfortable. I don't think you've reached that part in your presentation. It's only the paper which I've read, if I'm not mistaken. Anyway, you wrote that they feel very comfortable, and as they are used to talking to and with the camera, which shed lights on how many families, which are not necessarily transnational, during the last year have experienced and displayed their family life online through Zoom, through Skype, through WhatsApp and Facebook, ranging from including celebrating birthdays, family dinners, even having regular Shabbat dinners in Israel, and also participating at times in Shiv'ah, the week-long mourning period in Judaism online. And this evidently is something that many transnational families have been experiencing for some years now, yet in a very different spatial context and different temporal timelines and trajectories, often in less privileged ways than, families who are not transnational and from middle upper class. So doing family via Skype, via FaceTime, experiencing, I would like to suggest to you, which I found very interesting in your paper, I observed that there emerges a dialectics of absence and presence, closeness and distance, knowing and not knowing exactly what's happening in your everyday life, family, feeling familiarity versus strangers as well, comfort and awkwardness. And I'm sure many of this workshop participants are familiar with these affects. This paper also demonstrates, in my view, the merits of online ethnography as they emerge in this paper, how domesticity in everyday life is configured and displayed while the researcher converses with the participants. I will quote here very briefly one of the beautiful sentences in your paper. While we were on call during interviews, they are moving inside the house. She's referring to the participants in her project, thus providing a sensorial experience of their living space, as well showing a glimpse of their domestic life, while showing the things they have in display, or while they are cooking or petting a dog. I think this indeed demonstrates quite convincingly what we as researchers can gain from conducting online interviews. Another comment relates to the study of doing and displaying families with objects, with home objects, which I think can provoke us to look at the biographies of objects. And here, of course, and I'm sure Anjali is very familiar with this tradition, the works of scholars such as Apoderai and Sophie Woodward, which you quote in your paper, and the ways you showed it so beautifully in your paper, the ways they move and circulate. And your discussion, for example, of transnational parcels is beautiful in itself. And it made me think about, of course, the classical works of gift exchange and Marcel Mauss, who talked about the objects as having a life of their own. And in your paper and your presentation, you present this as creating transnational, but also local reciprocities. This indeed can be a point of departure to learn more about the biographies of families, their pathways, including family members who are not present, some which the family member does not keep in touch with or not in frequent contact with. In addition, these objects have much to tell us, when and how they are displayed in the house or in the restaurant, as you discussed, in relation to the story of the painting. And also to think what is not put on display, again stressing the dialectics I've mentioned in relation to presence and absence in a different way, and thus keeping some of these objects alive and getting rid of other objects. And in some ways, it is also connected to past events or future events. So we can also think more about how display via home objects are interpreted and evaluated by different family members. What makes particular objects more meaningful and more recognizable, but not in the same way to the members of the same household. Think about how the meanings attached to objects, and I really loved your analysis as well of the mobility of books, how the book moves from one country to another, can change. And in that respect, the object itself changes and endures. And all these are relevant, I think, to the study of cross-border mixed families in ways which incorporate the human-to-human relations, but also human to objects, as well as the relations between the objects themselves, incorporating various levels of analysis, the material, the discursive, within particular situated context. To sum up, this begs an appreciation also, as you've mentioned, to the effective relationship of humans and home objects, and making a home, feeling that you belong or you feel discomfort in a particular place, and how these effects are carried out and practiced through objects. And objects thus have in themselves effective qualities for different family members, for the migrants and the non-migrants. For some objects can give hope and strength, even authorization. Other members may be affected in entirely different ways or not affected at all. But these meanings and configuration can change over time. As objects move, they get stuck, their meanings change over time. And thus they attain different meanings in ongoing relational and fluid ways. In this manner, as feminist materialism teaches us, binary distinctions between subject and object or human and matter are destabilized. So I think this paper can urge more scholars to turn the gaze towards the doing and displaying of families, but not only families, also friends and family members beyond the nuclear family, as well as moving beyond a humanistic approach of social life and looking at the stories of humans and things, the mobility of these relations, the circulation of objects and effects, creating connections, disconnections in cross-border families. Thank you.
Not only a beautiful paper, but also brilliant comment. Thank you so much. While you're thinking about things you want to ask or add or comment, just a quick view of mine, being a lawyer, knowing nothing about sociology and anthropology. I must say that this really beautiful paper makes me think about the identity, not to say nothing about the importance of life and being secure and not being in risk, just to think about the consequences of a pandemic on the identity of immigrants that can't bring things, can't get things through the post, and just not being at home, not feeling belonging. Objects are so important for us, and we sometimes not thinking about it, but this paper just illuminated, and it was just beautiful. So thank you so much.
Well, thank you very much, Kenneret and Ruth, for the very generous comments. And I would say that Kenneret's comments make me also all the more think about several aspects of the mobility of objects and casting them also into some kind of binaries, as what cultural sociology is trying to, to emphasize. And maybe I will just comment on the three things that you mentioned about family as a verb. And doing online ethnography and also the social life of things and the agency of these things. First, the family as a verb I find very, very interesting, and I can also talk about this in terms of the nuances in the spaces inside the home as experienced by mixed couples. Those mixed couples that I talked to in Vietnam have a very different experience, and these couples are mostly, let's say, based on my field work, they would tell me that they are, for example, sleeping in different bedrooms, and that is how they experience also their intimacy. They would in fact talk more about their couch more than the bed, because they would say that the couch is a very important object in their home, because this is where they reunite as a couple, because they are sleeping in different bedrooms. They have two different TVs, because the Vietnamese woman likes to watch telenovela, softer romantic movies, while the Belgian man wants to watch racing and cars, something like that. And so the way that they negotiate their difference is by creating these spaces, but at the same time created spaces and objects of we-ness. And this is one aspect of how we should look at family, that family is in fact, of course, diverse, like what Colette mentioned, and I'm very happy to see you, in fact, because I read all your works on conjugal mixedness, and you talking about couple as an ongoing process is very much related to that homing. That homing among these mixed couples is also ongoing. It's accumulating we-ness, in fact, throughout the life course of the couple. And in terms of online ethnography, it's an impact of the pandemic. In fact, I didn't think about doing online ethnography until there was a pandemic, because I needed to proceed with my thesis, and I'm already on my third year of PhD, and I didn't have a lot of data yet, and so I had to force myself to bring material methods into the online, which is in fact very challenging, because when we talk about material, it's sensorial. I have to witness how the informants would touch their Buddha, or how they would touch their cabinets, and that is part of object interactions, and how they smell, for example, the rug or the sofa where the dog is peeing, for example. And this is something that is absent during the online ethnography. But also, online ethnography gave me another perspective into how these migrants, especially Vietnamese migrants, would consider the webcam as something that is it's like the world behind the webcam is another social space. For example, they would also speak about intimacy while we are doing online interview, like what Kenriette mentioned. They would walk around during the interview, and from living room they would go to the bedroom, and finally I see the bedroom. When I do face-to-face ethnography, I don't enter the bedroom. But during online ethnography, they would shift from different spaces in the home until I see how the bedroom is arranged, because they would talk to me while lying down on the bed, for example. And lastly, about social life of things, I wanted to also emphasize on the agency of the object itself. And this is something that is missing in different sociological and even anthropological works on migration, that the agency of objects is very important. What do we mean by agency of objects? That objects have power towards us, that they can make us do something that we would otherwise not do. Let me talk about an example during my fieldwork, where there was this couple who was fighting all the time because they wanted to remove the broken radio from the living room, because it's broken, basically. And then the Belgian husband who owns it doesn't want the wife to throw it away, because it's a radio of her grandfather. And so the agency of the objects here talk about the power of those objects to influence how this couple would negotiate their let's say, I mean, the presence, the mere presence of the object would influence how they would decide what to display and not to display, and also the stories behind those objects, even if they are broken. So what I wanted to argue here is that even broken objects have agency. Even if they are not functional anymore, they have agency. Okay, maybe I will stop there so that we can accommodate more questions. Thank you.
We are actually right on time to move to our concluding session, but if someone wants to say like a quick remark or something.
I think we can use the chat both for Nofar and Anjali. Brilliant presentations, not enough time to comment on. So either the chat or please contact them directly. They are still students, so they need us the most. Thank you so much. It was really fascinating.
Thank you. So now to Sharon and Sylvie. Thank you.
Thank you. I don't know why you're saying that they're still students, so they need us the most. We all need each other. I think this is the biggest take-home lesson from this year or year and a half. So thank you, everybody. Thank you to the brave souls who are still with us. Thank you to the presenters, the respondents, the chairs, Einat Meital, who helped organize all of this and did so brilliantly. Thank you, Daphna. Thank you, Academic Committee. Thank you, Minerva Center and Tel Aviv University. Now to business. So a little after the pandemic started, my Netflix feed featured a movie from 2011, so nothing new, called Like Crazy. And since it was about an international couple, obviously I felt like it's a professional duty to watch the movie. I do not recommend, I did not enjoy it, but still I watched. The movie is about a couple of an American guy and an English girl. They meet in college, and she's in the US for this. Towards the end of, so immediately after the end of school, her visa expires, she stays a little bit longer, so trouble with immigration. She moves back to England, and then she expects to be entered back into the US to stay with her boyfriend, but the State Department does not allow her to issue a new visa. And the relationship unravels from this because they can't be together. He can't come to England for some reason, not very convincing. She can't be in the States because of visa. And the relationship, it takes many years, the relationship unravels. So the story of the movie is the relationship, but really I think the story for me was the shocked glance or the shocked gaze of this couple at laws, at borders. So all of a sudden they have to understand that there are laws in the world, that the laws apply to them, that it's not just Mexican immigrants who can't enter the US, but it could also be an English immigrant. And the law could sometimes tell you no. Even if you have a great love story, the law could sometimes tell you no. So sometimes I think that speaking of family law during the COVID crisis somewhat resembles this movie because it makes the general public, makes them concerned or aware, maybe for the first time, of problems that all of us who deal with these fields, and more importantly, those who live with the field, they've known about it for a very long time. So there's no doubt that the COVID crisis is an exceptional event. Hopefully I would never live through this thing again. So we hope it doesn't happen again, but like the papers we've heard today show, even when something exceptional happens, the problems are often the same problems we always have. So we go between struggles with the same problems we already have. So I think COVID, for example, stresses the stress between individuals and groups and between borders and communities to a globe-ordered or an international community. It stresses the importance of family and physical houses. All of them questions which international family law has been dealing with for years. In recent years, family law and the world maybe in general imagined family a bit differently. It imagined a more broad, a more flexible institution. We've heard concepts like living apart together, which was a valid family form. We've heard a lot about international child custody arrangements. All of those assume that families do not have to live together to be together. But when the crisis hit, the pandemic, which pushed all of us back home, showed us that really we can be apart for a while, but essentially we want to be together. The pandemic changed our houses. It's not just the home, it's not just where our family habitus happens, it's not just the private, it also is the public. I think most of us, or many of us at least, are having business engagement from home, right? It's not just our emotional center, it's also our practical center. And this stressed emphasized the difficulty or the gap between the physical home and the emotional home, very similar to what Anjali mentioned, that we need some sort of an emotion to make the house a home. This movement home also refocused us on the meaning of the classical meaning of a family and the challenges that stem from that meaning. For example, the pandemic made things much, much worse for those for whom the house was not a safe environment, right? So we all went home, but for some people going home is not a good idea, either because there's poverty situations, so there isn't really a home to go to, or there's violence and home is nowhere you want to go. So in this sense, the pandemic disillusioned us or further disillusioned us regarding the normative or what is normal in family realities, and also about how good and how effective are our legal solutions and our legal thinking, maybe even. So globally, one of the main challenges in the COVID pandemic or the COVID crisis was the importance of community vis-a-vis the need to separate yourself from the community. And this is both in the personal level and in the international level. So from the get-go, COVID is a group challenge in the sense that we have to work together to defeat this. We have to work together to separate from each other in order for this not to be spread. But on the other hand, yeah, we have to work together to separate, right? So the rules of engagement here meant that we shouldn't engage with each other. We should live separately, each in our own home. And so it put an enormous amount of stress on the individual. We hear a lot about loneliness and people who are just thrown out of society. It put a lot of stress on family. But also in the global level, the COVID pandemic requires both international cooperation. So we have to work together to avoid people moving the different variants from place to place. We have to work together towards a vaccine. But we also saw that countries wanted not to work together, but they closed borders, right? So if we know there's a variant in country X, then we want nobody from country X to enter. And this creates limitation and suspicion both towards foreigners, but also towards local people or citizens who were away, like as the way Yuko mentioned in her presentation. So the corona pandemic deeply influences the sense of home and its meaning, and also international cooperation between countries and the strength of borders. In this sense, it tried not only the global family, but also not only the global family of nations, but also, and more significantly, the global family. The pandemic stressed the need to smartly use legal tools. And this maybe the majority of our papers mentioned this or addressed this point. So Ona Schoss, for example, showed how with regards to the Hague Convention for against the abduction of children, showed how we can use the existing rules in a wise way in order to manage the new problems or the new versions of problems which COVID introduced. The smart use of legal tools is also relevant to using terms and rights or aligning terms and rights between countries. So for example, the pandemic, as we mentioned before, stresses the lack of interest of the law in love. The law is not interested in love, but it is interested in formalized and recognized relationships. So the way Betty DeHaat and Beit Colette mentioned, the pandemic was not very, the pandemic stressed the countries in lack of interest in families which are not marriage, right? And so we have to think again about what does a family mean? What is the protected unit that we want to allow allow immigration, allow other rights that are relevant. Similarly, the pandemic did a similar thing with surrogacy. So recognizing the family of, if we want to, I'm not sure we want to, but if we want to recognize the family of the intended parents and the surrogate, then this has legal meanings, but we have to agree that this is something we recognize. Otherwise, if one country recognizes and the other doesn't, this doesn't work, as the pandemic demonstrates. This open-eyed understanding might also help us deal with problems that we somehow managed, or not everybody, but some of us managed to ignore up until now. For example, the access to abortion, which is in the US is a hugely critical problem. the thought of, I'm thinking of a 16-year-old who has to now to know where to go and then to cross state lines and to pay for all of this. So now it becomes everybody's problem, not just the 16-year-old who is ill-informed and lacking money, the way Nofar mentioned. So I think this is also something that the pandemic helped us become more aware of. And it hopefully will push us to create more fair rules that will serve both state interests, which have maybe been ignored for a while, but now we see that they are still in play, and also the interests of individuals in society, and particularly the weaker part of society, for whom crossing borders, either national or international, is very expensive and very difficult. In this way, and if there is a ray of sun in the end of the tunnel, the pandemic might help us improve the law. It might help us understand what we want to protect and why, and thinking or rethinking about how we want to protect it. And it also might help us to honestly say what we don't want to protect and why. Right? So if we don't protect it, it's fine. We have to justify it. And if we do protect it, we have to think about it in a smart way. On the other hand, and this is my last point, so I've been trying to be optimistic, but I'm thinking that maybe the bottom line is this. The pandemic also, for me, I think, at least, reaffirmed the overriding power of reality and of power over law, over my wishes, over other things, over my rights, right? So I can use human rights arguments, but at some point, if the state decides to close a border, then that is it. I can go to court, but I might win or I might lose. I'm thinking that someone mentioned before that we might be pushed towards less international families. Yes, this may be a reality, because we now know that international families are a risky and expensive business. You can't always avoid it. So the child abduction, you can't avoid it. If it happens, it happens. But I think the pandemic reaffirms global borders and reaffirms the challenge and the risk we take when we live in a global world. So it maybe makes us more aware of the sensitivity of international families, and more aware of our duty, everybody, policymakers, citizens, to be very careful when we deal with international families. So as usual, the family, and particularly the cross-border family, pushes us to deal with many challenges that we can't solve all of them. We can only solve some of them. But thinking about those challenges through the extreme prism of the COVID crisis might help us reorganize our thoughts about this. And maybe the international cooperation mechanisms that were developed and are still being developed might help us to serve partnerships and cooperation in other familial contexts for the benefits of everybody. Thank you.
I think I have to conclude, and I have to conclude with an optimist approach. Okay. I want to stress and emphasize what I've been emphasized before. Do you see my things?
Yes, Sylvie, everything is good.
Okay, thank you. To stress the technology and creativity, which Professor Trigger spoke about, and to relate it to human rights. For that purpose, I just want to pass to overview in 5 minutes, not more, I promise, the new idea of Zoom wedding. So in the spirit of our call for papers, I want to rethink with you all what we have heard, but to take it to a new direction, to the direction of an optimist future. So I speak about Zoom wedding, which offer new possibilities for all over the world, and we can be a revolution in Israel. So what is about? As we have heard, when the pandemic scattered couples planned to get married, there was a new creativity, a new way open, Zoom wedding, which is accessible to everyone, and it is low cost. And moreover, it includes interfaith marriage and LGBT marriage. So Utah state was announced in February 2020 that it would recognize marriage conducted via the internet, even if the couple were not present in the state at the time. In fact, couples don't even need to be physically together for the ceremony, as long as an officiant can see and hear both of them over video call. Utah, and it's very connected with what we have heard, also became the first state in the US to recognize a virtual Zoom wedding between partners living not just in different states, but in different countries. There were also pressures for religious marriage by Zoom. I read something very interesting in Indonesia, but it's not connected to the idea of free access to marriage, so I leave it. Finally, in April 2021, Zoom marriages became legal also in California, in New York, and Ohio, and in Colorado. I suppose that is now also legal in other countries. I want now to refer to what is happening to Israel. We have heard that we are very specific. We have not civil marriage, but we try to circumvent the situation. So generally, couples who don't want to cannot be married in a religious ceremony, such as those who are forbidden to marry. We call them in Hebrew psulei chitun, LGBTQ, interface, or people without religion. I will explain what I mean by this expression. Can live in cohabitation, it is recognized in Israel, or travel outside of the country to be married civilly before bringing back their civil marriage license to register with Israeli officials. Israel is obliged by international law to recognize such marriage. Of course, the pandemic severely limited couples' ability to travel outside of Israel for such marriage. So, of all the categories I mentioned now, without religion is the biggest one. It amounts to 448,000 people. These are former Soviet Union newcomers who come to Israel from the 1990s, last century on, and their children. The problem is like that. For the law of return, the law of immigration to Israel, they are Jews. But for the Jewish law, what we call among Jewish people, halacha, they are not. For instance, father is Jewish, mother is not Jewish. And the child is not recognized Jewish because Judaism, according to religious approach and law, is transmitted by the mother. So there are a lot of people from the former Soviet Union which cannot be recognized as Jews by the halacha. These Jews are no faith. They are not Jews by faith. They are Jews by national identification, and only 7% under convention from 1990. There are the biggest majority of those who marry outside to circumvent the religious establishment. And of course, when this new opportunity of Zoom wedding was open last year, most of the people who came to this opportunity were Jews from the former Soviet Union or LGBT couples or interfaith couples. This created a problem, of course, because at that time, and you see that I put it in red because I am very happy to put it in red, ex-interior minister, which was the leader of the ultra-Orthodox party, was against this marriage, and he stopped this process. But till to 2021, 150 marriages of Israeli were registered in Utah. For the moment, the process is stopped. There is a petition to the High Court of Justice over the issue, but we can be optimistic because we have a new government and the action of Minister Deri was totally illegal. So it can be a revolution. My conclusion, so I hope to see my conclusion in the future. I am optimistic about this process, and regarding what we have spoken in this conference, I think that we should think over for a new future with Zoom wedding and Zoom in general, which can be positive option also as far as cross-border families are concerned. So thank you for your attention and thank you for your presentation.
Thank you, Sylvie. Wonderful. Thank you, Sharon.
I was short. That's the best thing.
Katharina, please. Oh, it's clapping. It's not voting.
Yeah, I'm clapping. I'm really fascinated by what you have just told us, Sylvie. And this really raises a lot of private international law questions. Where is the place of celebration? Which formal requirements must be fulfilled? And all these kind of things. So we're looking forward to the court decisions of Israel in this respect.
We also. Thank you, Catherine. Thank you.
Yeah, I think this is one court decision that we're waiting for. I think that by and large, we saw in this workshop that there are still many legal issues that we need to explore. The law was less present than in usual legal conferences because we're still in the process. So we have so many things to look at and reflect on. And I think that part of the question is, do we have enough distance from the crisis yet, or that we are still so deep in it that we maybe lack the perspective or even the motivation because we need to distance ourselves. I was in a conference last week. There were, 20 presenters, and the word COVID appeared only once. So I think many of us just want to, to put it aside or behind us, and it will take us time to be healthy enough, with enough well-being to go back and reflect on this very complicated and damaging period. So Sylvie, thank you for this, optimistic story about the new possibilities. I think it's really, really important.
Thank you.
Anyone else want to say some concluding remarks? Sharon and Imen.
I'll do it very quickly. I'll just say that I'm absolutely not sure that those weddings are valid. Even the ones we do register, but we don't say that they have anything in validity under the Funk-Schlesinger decision. So it saddens me to say, but I think Prime Minister Deri was on the right here. Those are not valid marriages. And even if the Supreme Court decides otherwise, it will not decide that they're valid because it has not decided anything about validity of marriage since the 60s for good reasons. So I'm not as optimistic as you are, Sylvie. I mean, they may register the marriages, but that would be it. Formal validity, I don't think they will have.
Well, registration is more than enough sometimes. So, Imen, please.
Thank you very much, Daphna. I am really very impressed and very happy, and I feel who said that law and sociology and science is a boring thing. Thank you all very much. You mentioned the intellectual adventure, and it was indeed an adventure. And because I want, first of all, to congratulate you for this, for the courage, to start this this initiative and to open the debate on this issue, which is on COVID, where many scholars are just, you know, raising the questions, but you brought us all together, and you help us give words, you know, give words to our thoughts and fears and hopes. So that's just what I wanted to say. Thank you very much for your courage and for your courage. It is not, it's a seldom quality. Thank you. Thank you all.
Thank you. Paul, please.
Yeah, I just wanted to say thank you to Sylvia as well for something I didn't know about. I didn't know about these US states that have allowed these online marriages. And I think actually it is a bigger point. I think you're right to maybe focus on it. Probably the biggest single effect of COVID in our future lives will be video conferencing. Online events. Mm-hmm. It's not going to go away because COVID goes away. That's for certain. Sadly, we'll have less academic conferences in person because our bosses will not fund them so much because they know we can do it now online. And I think we'll have to adapt to that reality, and laws gradually will have to adapt to that reality. And so therefore, the idea of online marriage makes quite a bit of sense, not just in an emergency in COVID, but in order to save a lot of sometimes unnecessary costs of people moving around. And people can afford it, would love to do it, but there are people who perhaps can't, and to be able to have their marriage conducted online where everybody can then participate could be attractive. So anyway, I do think that's the private international law, as a fellow like Katharina, as I think about it that way, we do have to think about how we adapt our thinking to that online framework. When e-commerce first came in, we were told there would be masses of changes, and I was a bit skeptical. And in some respects, our laws don't need to be adapted too much. They have been adapted a little, but we haven't had to think about it in the family context up to now. But I think COVID probably does push us into beginning to think about the effects of the online world and how the online world may need to be accommodated by our legal frameworks in a way that we haven't thought about before.
Thank you. I think that we can learn from the familial sphere that there are things that you cannot do as a family just on the virtual world. The same goes for academics. I truly miss the small talks that we would obviously have over dinner with good wine after the exhausting and interesting session, talk with each other, learn more about each other as humans, as family members, for our future projects, for further discussions and thoughts. So I do hope we will convince our bosses that it might be nice from time to time, but certainly not a replacement of actual physical meetings in one place or another. So thank you all. Thank you, the scientific committee. Thank you, Einat. We could have not done that without you. Thank you, wonderful speakers. Thank you, Yuko, for staying. I know it's the middle of the night at your end now. You're certainly a brave participant. And I do hope we will continue this fascinating conversation after quickly COVID is over and we are all safe and sound. Thank you. Good night from Israel.
Bye.
Bye. Good night. Thank you.
Thank you.